Sir, is that registration everything with that vehicle matter, that one. Now, permit of the permit is not giving now. He was now.
Okay, I know next week.
Anything.
I will spoke there. That is one is active vacancy, including cancellation order. Passed by the registrar without hearing properly, taking up the matter. So
What
the-
cancellation?
Cancellation of the cooperative society.
Huh?
Cancellation of the cooperative society.
Cancel cooperative society?
Well, it's
5.
what happened, Malo?
When's 5? Cooperative society.
Earlier, we,
Earlier, not nowadays. When you know, I look.
in the month of June.
When's 5?
We preferred a matter for the bank score. That is why in the month of June.
No, since August, it has been changed.
Well,
What's a report listing of a content case, my lord? Last list of 36, my lord. Therefore, it's not going to matter pertains to release of non-payment of the contractual fees, my lord. Any date, my lord?
Last.
I'm applied. Maybe you can mention. I just to mention item number 11 and 12. The hearing matter number
11 and 12.
11 and 12.
Yes.
Possible the matter may come after vacation, right?
After?
Vacation.
After vacation. Okay. Is there any interim order?
Internet.
Have you informed the standing
Yes, I
council,
informed
ABC?
Sir.
Okay, Mr.
F.A. Hassan on behalf of visitor.
A.K. Hassan,
F.A. Hassan.
F.A. Hassan,
Yes,
learned counsel appearing for Mr. Bididas,
yes, visitor.
learned senior counsel for the petitioner, has paid for listing of the case after 3 weeks. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer. Last 5 days, there is no mention of interim order.
One case is the interim,
Yes.
then the WBC number.
Yes, yes. 11 and 12.
First, I take to mention repetition lordship for listing for tomorrow lordship.
Listing for
Tomorrow lordship.
new matter,
No lordship, it's fixed for the admission hearing lordship.
fixed for
Admission hearing lordship.
what is the subject?
Lordship pertains to settlement of weekly market lordship, Sunday market lordship, Sunday weekly market lordship. Now
Is it
lordship,
fixed tomorrow?
no lordship. I just paid before the honorable court to fix the matter for tomorrow lordship. Because already.
Already number of matters are listed. Next.
May it please, your lordship. But a slight accommodation is prayed for. We filed the writ petition a day on 25th. I'll pray for listing tomorrow if lordship permits.
Motion.
Motion. I would have paid today, but I'm praying for tomorrow. Some difficulties have been created by the partners. Obliged, lordship.
Listing, my area rain, my vehicle is requisition, that was.
Subject?
But deputy commissioner.
Hey, move my for okay. Huh?
My lord,
Okay. No, I think no.
my lord, rain, area rain, my lord, vehicle is in requisition, this is. So that is not released, my lord. but
Okay.
Since 2000. Next.
Court master give it.
Yeah, please, your lordship. I beg to mention item number 9 and 10, lordship. Kindly matter will be adjourned for 1 week, lordship.
Why?
Why, lordship, we have to seek instruction from the client, lordship. Matter relates to settlement of market, lordship. For this.
You are MS?
J. Ghosh on behalf of SC Diswas, lordship.
MS J. Ghosh, learned counsel appearing for Mr. S.C. Vitsas has paid for listing of the case after it is submitted. Have you informed the other side? You have informed? The constable video. Please the case will start. Same thing. Same item number 10. Make it start.
Contempt matter on that. In next month, any statement.
Not next week, next to next.
And earlier it was listed month 24,
Like
7.
next to next week.
Please, Your Lordship, I taken for listening of the member.
Subject,
Yes, Lordship, what even the matter is, I file an repetition.
subject,
Yes, Lordship, the matter is infructuous now.
infractuous,
So I want to withdraw the.
withdraw.
Yes, Lordship.
Your Lordship, I'd like to mention a repetition for listing next week. The subject matter is settlement of markets.
File of review.
Please, Your Lordship, but your document for listing of each person member, subject matter, non-payment of contractual fees.
Next to next week. Next to next week. Next to next week. Contract.
Daily list for admission, item number 1 to 4.
My lord, before starting the case, my lord. In item number 3, my lord, affidavit has been filed, my lord, by the department, and we need to file reply, my lord. So I pray for 7 days time accommodation. In item number 3, my lord. Department has filed an affidavit of opposition. So we need to file reply, my lord. And it is
Sir,
7
who has
days,
brought these matters for by order?
lordship.
Who?
At my instance, my lord,
He brought.
because my lord, in the first case, my lord, I was respondent number 5, my lord, and in that case, I filed my color number, but affidavit yet to be filed. But the so far, the my lord, first case is concerned, it is my lord infractuous, because my lord, by the order that is passed on my lordship on
These are all tagged or what?
take my lord
all tagged.
for the settlement of the same ferry service. 2 ferry services, one is my lord Rajnagar, another is
Which
Jatin.
one? Item number 3, government file
Item
affidavit.
number 3, my lord, they filed the affidavit. We need only 7 days time, my lord, to file the reply. Then, my lord.
But in 3, my lord, copy has not been served to me. So
Copy of by whom?
by lord petition number 3 and 4, I have not received the copy.
I have taken steps anyway, I'll supply.
J.I. Barvia. Learned counsel for the petitioners, appearing WP number 1, 3, and 4. For the petition. As submitted that in the petition, WBC number 85, 2020. The respondent number 2 has filed an affidavit in opposition. And he prays for, yes, paid for 1 week's time to file an affidavit in reply to the affidavit in opposition filed by the respondent.
According to success, not mine.
Mr. Mohanto, P. Mohanto, learned counsel for the petitioner in WBC 8323, 2000. Submitted that in WBC 835, 2023 and WBC 1606, 2023. He is a party respondent with a copy of the writ petition along with copies of the writ petition along with not been received by him. So, Mr. Bormiel, I will talk about the petitioner. Shall furnish copies of the 2 petitions along with access to Mr. Mohanto by tomorrow. Release the cases after 1 week.
My lord, so far the item number 2 is concerned, my lord. Actually, my lord, I have challenged the my lord settlement, my lord, tender committee favoring his settlement as a response number 4. But without complying certain my lord documents which are not annexed with the my lord the tender paper as well as not complying as per the tender condition. So ultimately, my lord, the respondent concerned, my lord, they have admitted the facts that it is a mistake. And
Now all are tagged together now. 4 petitions.
now, one thing, my lord, kindly, my lord, as the review committee has already reviewed in my favor. And the earlier occasion, my lord, the lordship has passed an order there is a no bar to give a decision in my favor. So, my lord, that may be considered because it is considered that I should
If
get
the
the,
order is already there, why should I reiterate?
no, this is not exactly in my favor.
Let the cases.
But
be
there is
after
no
1 month.
bar.
Okay, we'll fix a date, mister.
My lord, interim order
What
to
of-
be continued, my lord.
And the so far, well, one is concerned, this is infractious, my lord. One is infractious.
Well,
My lord, interim order possible to be continued.
interim order. If any.
That is, my lord, listed on 16, my lord. Because there is urgency,
So
because
16 is too
my lord,
nearer to the puja package.
my lord, law because the
Well,
tender period will expire in March
10.
12th. All right. Tell me.
Lordship, I am appearing for 123.
MD Bora.
Give your name.
Master.
Item number 5.
But the matter pertains to a tender for supply of liquid nitrogen.
Yes.
If your lordship will come to the NIT, which is at page 38. Your lordship sees page 38, the Assam Livestock Development Agency hereby invites sealed bids from eligible bidders, etc. In the chart, your lordship will find the quantity of supply is 12 lakhs. But at page 60, 6 will reveal that this 12 lakh liters is to be supplied in quantities of approximately 1 lakh liters per month. Your lordship will kindly come to page 66 for a moment. 5.1, subclause small Roman 1. Your lordship will find there is a relevance, madam, that is why I am pointing this out. Procurement quantity will be 1 lakh liters approximately per month for a period of 1.
Yes.
Now, there is another important aspect, my lord. At page 38, your lordship sees subclause B. Open competitive bidding method shall be followed for the selection of most preferred bidder for the tendered items. The tender terms, conditions, and procedures are in conformity with Assam Public Procurement Act 2017 and Assam Public Procurement Rules 2020. So essentially, my lord, this is a statutory tender under the Public Procurement Act. At subclause E, your lordship will find the last date of submission is 17th of June.
Yes.
And subclause G,
Subclause.
the date, subclause G1.
Hmm.
The date of opening is 20th of June. 17th June, last date of submission, and 20th June, date of opening. If your lordship now turns to page 47,
there are two clauses which are relevant. At clause 2.5, your lordship will find bidders eligibility. 2.5.1. This has a incidental significance, Mala, that's why I'm pointing this out. Bidder shall be a sole business entity having a formal intent and legal competency to enter into an agreement or contract and are registered under respective act and jurisdiction in India. And down below at 2.6, your lordship will find bidder's qualification. Bidders should substantially meet the qualification criteria as stipulated in section 4, evaluation and qualification criteria. This section 4, evaluation and qualification criteria, your lordship will find at page 64. We are not really concerned with the evaluation, but the qualification criteria is relevant. Section 4, clause 4, evaluation and qualification criteria. This qualification criteria is at the next page. And these are the qualifications based on which the entire case hinges. If your lordship has page 65 qualification criteria. 4.2.1. The bidder, if not the manufacturer, should have the installed capacity of supplying goods of similar in nature to different government departments, undertakings, entities of 1 lakh liters quantity per month during last 3 financial years, 1920, 2021, and 2021-20. Your lordship will note there are two important aspects. One is similar supplies have to be made to government departments, undertakings, or entities of 1 lakh liters per month and during the last 3 financial years. Now, next 4.2.2, the manufacturer of the quoted good should have valid manufacturing license and an experience of manufacturing and supplying of at least for last 3 financial years ending on 31st March 22. Details of supply similar contract for during last 3 financial years, that is 1920, 2021, and 21-22 needs to be furnished. So what this says, 4.2.1 says that the bidder necessarily need not be a manufacturer himself, but he has to have a installed capacity of supplying 1 lakh liters to government departments, undertakings, entities, etc. in the last 3 financial years. And 4.2.2 says that whoever is the manufacturer has to have manufacturing license and an experience of manufacturing and supplying of at least for 3 financial years ending 31st March. In the financial years are mentioned. Now 4.2.3, there are 3 clauses which are relevant. Subclause A. Bidder must have own production plant.
Yeah.
Bidder must have own production plant or bulk storage facility minimum capacity of 1 lakh liter per month in Assam. Details of cell phone infrastructure should be furnished. So either you can have a own production plant, or if you don't have it, you have to have a bulk storage facility of 1 lakh liter per month in Assam. Now, subclause C, location of plant storage facility should not be more than 150 kilometers from the operational headquarters of ALD at Khanapara. Location of plant storage facility should be furnished. Now, D, plant storage facility must be having adequate restrooms for drivers and staff deployed for collecting the liquid nitrogen by transport tanks of ALD. Now, your lordship has noted that the last date is 17th of June. What they do is this. Page 101.
Yes.
Your lordship will kindly note the date of this corrigendum. 17th of June is the last day. After the last day, on 18th of June, this corrigendum is issued. And your lordship will kindly peruse the content. Makes very interesting. Due to single weight participation, till the closing date for the procurement of pure liquid nitrogen against NIT number so and so, it is felt that qualification criteria is not supporting medium scale industries enterprises for participation. Hence, it is decided that the qualification criteria be relaxed as follows for wider participation. If I may pause here for a moment, madam, this single bid that has been received is my bid. So after receiving my bid, they modify the qualification criteria. And your lordship will kindly note that when you do things in a hurry, without applying your mind, this is what happens. Clause 4.2.2, evaluation and qualification criteria, section 4. The bidder, if not manufacturer, should have installed capacity of supplying goods of similar nature up to 1 lakh liters quantity per month in multiple consignments during the current financial year 2020. If your lordship will kindly have this with page 66 for a moment. They were in such a hurry to favor the private respondent. Even the clause is wrongly mentioned. It should have been actually in the corrigendum. It should have been 4.2.1, not 4.2.2. If your lordship compares the language, your lordship will find that this actually is a modification of the clause 4.2.1, not 4.2. And what they remove is two interesting things from 4.2.1.
Yes.
Your lordship will find at page 65, there are two very relevant qualification criteria in 4.2.1. One is that similar nature supply has to be made to government departments, undertakings, and entities. That is removed. Now, it can be interpreted to mean that you can supply it to any private organization also, where the government will not have any scope for verification of the authenticity of the document, whether actually supply has been made at all. That most significant portion in 4.2.1 of having made similar supplies to government departments, undertakings, entities, that portion is removed. And 3 financial years has been removed to just current financial. Now, my lord, if I may just take your lordship to the procurement rules for a moment. It's a very voluminous rules, my lord. I have just given the relevant portion. In the 4th page, your lordship will find rule 23. This runs into almost hundreds of pages. I've just given the relevant one. At the 4th page, your lordship will find rule 23. And if your lordship turns the page to sub rule 16.
Yeah.
Subclause 1 of sub rule 16. Subject to the provisions of section 7 and section 14 of the Act, technical bids shall be evaluated solely on the basis of the criteria or terms and conditions set forth for evaluation of technical bids in the bidding documents and in accordance with the procedure here in this rule. The criteria and terms and conditions shall be clearly mentioned in the bidding documents so as to maintain transparency in the evaluation and selection. Next portion is very important. Such criteria or terms, once fixed for evaluation of technical bids in the bidding document, shall not be changed or relaxed under any circumstance. Bid shall be evaluated only against the criteria specified in the bidding document. So, my lord, the corrigendum that was issued itself was in violation of sub-rule 16 of rule 23 of the procurement rules. However, my lord, since they had mentioned that they are relaxing only because on the ground that a single bid has been received, we did not raise any objection. We said, all right, you go ahead.
Yeah.
Now, after this relaxation by the corrigendum, the private respondent submits the bid. And the evaluation, your lordship will find at page 102.
Yes.
Page 102. They have made a comparative assessment of the evaluation. Premier, there are in that chart, your lordship will find two parties. Premier Cryogenics, that is the petitioner. And on the right side, your lordship will find Meghalaya Oxygen Private Limited, that is the respondent number 6. If your lordship will first come to serial number 4, manufacturer's authorization. Your lordship will find my credential, own manufacturer. And this Meghalaya respondent number 6, your lordship will kindly see, submitted the authorization letter issued by SD Cryogenics Gases Private Limited, Sandop Jongkar, Bhutan. So the manufacturer is not even registered in India. Now your lordship will kindly come to serial number 11. Your lordship will kindly see my production capacity. 70,56,720 cubic meters. And your lordship, the respondent number 6 does not have any manufacturing capacity at all. And even that Sandop Jongkar, Bhutan, has a manufacturing capacity of 37,500 cubic meters. And obviously, this ALDA has no way of verifying legitimately. It's a foreign country. So where is the scope for even verification of this? But let us assume that this is the correct figure. Now your lordship will kindly come to serial number 13. Location of plant, so far as I am concerned, one is at Samaguri, Nagaon and Suakosi, Guwahati. Combined storage capacity is 2,56,442 kg. Per month we have to supply 1 lakh. And your lordship will kindly see the respondent number 6. Location of storage, Sandop Jongkar, Bhutan. And the storage capacity so far as Bhutan is not even given. Amingaon, Kamrup, storage capacity 40,000 liter at Amin. Now at the bottom, your lordship will find the remarks. I am responsive. And what they do is, they are not satisfied by relaxing, issuing the corrigendum. They further relax to submit shortfall documents within 21/7/22. And your lordship will kindly just make a note of one more thing in this document, madam. 3 persons have signed this. Your lordship will kindly make a note of this Bofonto Kakoti. 14, it was signed on 14/7/22. This again has a significance. Now they allow him to improve his tender. And after whatever is submitted, page 103, next page. This is the decision that the tender committee did. Report on shortfall documents of Meghalaya Oxygen Private Limited. The bidder's credentials regarding supply chain mechanism with the producer in Bhutan were thoroughly verified by the committee. How? Did you write to Bhutan? The committee is of the opinion that the understanding between the producer and stockist bidder is pre-existing, and the possibility of any interruption in the supply chain of the liquid nitrogen is unlikely under the present circumstances. The FDI document is not related to the supply chain and its validity is not a matter of concern for the purchaser. Hence, the committee is satisfied that Meghalaya Oxygen will be able to supply liquid nitrogen to LDA on a continuous basis with the existing infrastructure of the producer in the Indo-Bhutan border area adjoining Tamulpur district of VTR, Assam, and the stockist bidder located in Amingaon, Kamrup. The Technical Bid Evaluation Committee recommends parallel procurement of liquid nitrogen from both technically qualified parties at the lowest quoted rate for operational advantage and uninterrupted supply chain. Your Lordship will just make a note again, Bohonto Kakoti signs as member. And your Lordship will kindly note the date, madam. It is 3rd of August 2022. This Bohonto Kakoti retired on 31/7/22. This is our pleaded case. At page 11, we have specifically pleaded, and this has not been denied. Page 11. If your Lordship will kindly come to page 11 of the writ petition. Yes. Third line from top, Mala, there is a sentence starting, however. However, it is pertinent to mention that the said report was signed by one Sri Bohonto Kakoti as a member of the Technical Bid Evaluation Committee, even though he had already superannuated from service on 31/7/20. And this fact has not been denied by ALDA in its affidavit. It is not in dispute. This is the extent of favoritism, my lord, that happened in this case. Now, what they do, we immediately submitted a detailed representation, which your Lordship will find at page 105. We said that how can you, this person has no credentials, no qualification whatsoever. How could you have even entertained his tender? And what we do is, if your Lordship will kindly have page 105 for a moment, our representation.
Yeah.
We have taken part in the above NIT of ALDA. As per clause 4.2 of the NIT, all bidders have to meet 6 qualification criteria to be technically qualified. As per Technical Bid Evaluation Committee report uploaded in portal, Messrs. Meghalaya Oxygen, etc., with a backup manufacturer of SD Cryogenics Gases Private Limited, Sanrup Jongar, Bhutan, has been declared technically qualified. We have gone through the bid uploaded by them as available in the portal and submitted that they do not meet even one of the qualification criteria. Whereas the comparative statement prepared have not deliberated on some of the qualification criteria at all, and in the others have relied on the quotation of the bidder without any supporting document. We have enclosed here with a clause-wise compliance statement for your reference. Not only is the bidder not meeting any of the qualification criteria, but it claims to be operating liquid nitrogen storage tank and transport tankers without the mandatory license issued by Petroleum and Safety Organization, Government of India, which is an offense under Explosives Act, punishable by imprisonment up to 3 years and or fine, etc. We submit before you, etc. We complain against this technical credentials, madam. And if your Lordship kindly sees page 106 onward, we have given in the form of a chart how the respondent number 6 does not meet the qualifying criteria against each of the clauses. I am not troubling your Lordship by taking your Lordship through each of these. He does not fulfill any of the criteria. Now, in spite of that, they keep quiet, and suddenly, my lord, on 4/11/22, this page 125 letter, page 125, is issued to us. This is from ALDA to us. With reference to the subject cited above, I am to inform you that the competent authority of ALDA has approved the lowest responsive rate for supply of liquid nitrogen to Assam Livestock Development Agency for 12 months at the following rates. The rates are given. Next paragraph, my lord. As such, you are allowed to produce and deliver an approximate quantity of 4 lakh liters of liquid nitrogen in 12 months. My lord, out of the 12 lakh liters, they give, with my credentials, they give me 4 lakh liters. So naturally, the presumption is that they sought to give 8 lakh liters to the respondent person. Because the total requirement is 12 lakh liters.
Yeah.
Now, when we receive this, under the Procurement Act, my lord, there is a provision for appeal. We immediately file an appeal, which your lordship will find at page 128. There is a provision for appeal under section 38 of the Act.
Yes.
Page 120. This is the format in which the appeal is required to be filed. And next page, page 129, your lordship will find the detailed grounds of it. Again, clause wise we have dealt with. Just to give an example, my lord, clause 4.2.1. So far as this is towards the right hand column, your lordship will find no document has been uploaded by the bidder that either the bidder or the manufacturer has made any liquid nitrogen supply to any government entity. The manufacturer has started operations in November 21. It clearly does not have experience of 1 lakh liter per month during the last 3 financial years. Refer to document uploaded by MOPL, etc. MOPL has no experience of government supply of liquid nitrogen in the last 3 financial years. It has uploaded supply document of only 41,492 liters in the last 3 financial years to WAMUL, which is not a government entity. Bidder has not even claimed in its bid that it fulfills this qualification criteria. Now, my lord, next page. 4.2.2. Install capacity of 1 lakh liters is the requirement. MOPL has stated, presently we are supplying liquid nitrogen to West Assam Milk Producers Cooperative Limited only. It has not submitted the required client certificate from AMUL or any other document to substantiate that it has supplied 1 lakh liter per month during current financial year. As per information collected from WAMUL, their purchase of liquid nitrogen during 22-23 is about 13,000 liters per month. Experience of supply of bidder in current financial year falls far short of the required 1 lakh liters per month. Bidder has not even claimed in its bid that it fulfills this qualification criteria. This qualification criteria is not deliberated in the comparative statement of technical committee. Now, bulk storage facility, that is 4.2.3a. MOPL or manufacturer does not own production plant of minimum 1 lakh liters per month in Assam. The plant capacity of MOPL is 4,46,400 liters per annum. That is 37,200 liters per month. Refer quotation dated so and so. MOPL has claimed that it has liquid nitrogen storage tank capacity of 40,000 liters in Amingam, Assam. No government document has been submitted to substantiate this claim. 40,000 liters falls short of requirement of 1 lakh. Next page, Malad. This is even more interesting. Every liquid nitrogen storage tank must have license issued by Petroleum and Explosive Safety Organization, Government of India, under Static and Mobile Pressure Vessel Rules 2016 to operate. As per PESO, RTI reply attached here with PESO has not granted any license in Form 3 for storage of liquid nitrogen to MOPL. They are not completely giving a go by to even the safety measures. Just to confer some favors on. Bidar has no licensed liquid nitrogen storage tank in Assam, and its claim of having storage tank of 40,000 liters is not based on facts. The committee has accepted the claim of the bidder without verifying any document. Now, this is how it goes on. I just pointed out 2, 3, but I am not troubling your lordship with all these. Now, the appellate authority passed the order, which your lordship will find at page 138. And this order has attained finality. No one has challenged this. The operative portion of the order is at page 139.
Yes.
Again, the appellate authority has also dealt with clause wise. So the findings are towards the right hand side. No document has been uploaded by the bidder that either the bidder or the manufacturer has made any liquid nitrogen supply to any government entity. This is the first finding. Then the manufacturer has started operations in November 21. It clearly does not have experience of 1 lakh liters per month during last 3 financial years. Refer so and so, etc. The qualification criteria is not deliberated in the comparative statement of the technical committee. This contention of ours has been accepted almost in totality. Next, 4.2.2. On perusal of the papers as well as the bid documents of the bidder, it has not been found that the bidder is not responsive to the qualification criteria, as the bidder itself has stated in the bid document that it has the experience of producing industrial gas only. They have set up 40 TPD ASU plant at Bhutan, 100 kilometers from Guwahati in November 21. Hence, there is no evidence of the fact that the bidder has installed capacity of supplying liquid nitrogen gas, and they did not have either the installed capacity or the experience to supply liquid nitrogen gas during 1920, 2021. Bidder has not claimed in the bid that they fulfill this qualification criteria. Now, 4.2.3a. They have installed capacity of 40,000 liters liquid nitrogen gas storage tank in Amingaon, Assam, which falls short of 1 lakh liters. The bidder did not have license or liquid nitrogen tank at the time of bidding, and the committee has not gone into the details of the claim of the bidder that they have 40,000 liters liquid nitrogen installed capacity. In consideration to the aforementioned and infirmity, it appears that the bid submitted by Meghalaya so-and-so is a non-responsive bid as per clause 11D of the Assam Public Procurement Rules so-and-so, wherein it is stated that the bidder must fulfill the eligibility criteria given in the bidding document. Conclusion. The undersigned is of the opinion that the NIT evaluated by Assam Livestock Development Agency is contrary to the provisions as laid down in section 10D of the Assam so-and-so Rules 22. Bid of Meghalaya so-and-so being a non-responsive bidder was accepted by the technical committee in violation of 10D of the so-and-so Rules 22. Hence, the bid is recommended to be cancelled. So, what the appellate authority said, that you cancel his bid. What they do is this one. Page 141. There is a, with greatest respect, there is a limit to favoritism. I think this ALDA does not believe in rule of law at all. Page 141. They cancel the tender itself. Instead of cancelling the bid, they cancel the tender. And they do not stop there. The Lordship will kindly note the date, 13/1/23. On the same day, a fresh NIT is issued, which your Lordship will find at page 149. Same day. Your lordship will find the date at the top right hand corner, 13/1/6, same date. And your lordship will find the qualification criteria at page 155. They removed all the qualification criteria in the earlier NIT. At page 155, your lordship will find clause capital A, qualification of bidders. None of those qualifying criteria that were there in the earlier NIT are there. All removed, so that they can bring in the respondent number. So this is what is under challenge before your lordship. Number one, the cancellation of the entire tender process and issuance of the fresh NIT. Both these things are under challenge before your lordship. And the challenge is, my lord, the primary ground is Rule 23, sub-rule 16 says that once you issue the NIT, you cannot modify it. So the first ground of challenge is, although it is, you want to call it a fresh NIT, it is a continuation of the first tender process. So this rule, sub-rule 16 of Rule 23 will squarely apply to this NIT also. It is a continuation of the tender process initiated by the original NIT dated 26/5/22. So you cannot change the qualifying rate. That is the first ground of challenge.
Rule.
Rule 23, sub-rule 16(1). If your lordship peruses that provision once again, the whole idea and purpose behind the rules is that once you have framed the tender conditions, you strictly abide by it and you cannot relax it. You tried to relax it. After relaxing it, also the respondent number 6 could not qualify. The appellate authority held his bid to be non-responsive. After that, even if you issue the fresh NIT, you could not have relaxed the qualification criteria. Now, my lord, when we file the writ petition, the respondents responded by filing their affidavit. In the affidavit, the grounds are two. First ground is that there is a difference in price. The respondent number 6 has quoted a lesser price. If your lordship sees the supply order made in my favor, I have been given at the lowest quoted price, which even if assuming, if your lordship comes back to the supply order of 4 lakh quantity liters, page 125. They have not been able to bring out any material to say that I have ever objected to this lowest rate. Even today, my specific instruction is that we are agreeable to supply at the low, this rate. The entire 12 lakh. The second my lord, argument on the ground of rate is, my lord, the answer is in Ronak International. Your lordship will recall, if your lordship kindly takes up Ronak for a moment. 1999, 1 SSC 492. Paragraph 9, if your lordship takes up paragraph 9, in Ronak, the apex code have laid down the parameters on which tenders are to be evaluated. What are the things that are required to be seen in a bidder? Para 9. As my lord got. The award of a contract, whether it is by a private party or by a public body or the state, is essentially a commercial transaction. In arriving at a commercial decision, considerations which are of paramount importance are commercial considerations. These would be the price at which the other side is willing to do the work. That is one of the criteria. Whether the goods or services offered are of the requisite specifications. So now they don't have any experience of supplying liquid nitrogen at all. They have been supplying something else, which is the finding of the appellate authority. Now, next 3(1). Whether the person tendering has the ability to deliver the goods or services as per specifications. When large works contracts, this pertains to works contracts, we are not really bothered. Now, 4(1). The ability of the tenderer to deliver goods or services or to do the work or the requisites of the requisite standard and quality. Next 5. Past experience of the tenderer and whether he has successfully completed similar works earlier. Each of these conditions, as has been laid down in Ronak, has been with venom and malice violated in this case. In fact, paragraph 11 says that a mere difference in, if I may place paragraphs 10 and 11 also. What are these elements of public interest? Public money would be expended for the purposes of the contract. The goods or services which are being commissioned could be for a public purpose such as construction of roads, public buildings, power plants, or other public utilities. The public would be directly interested in the timely fulfillment of the contract so that the services become available to the public expeditiously. The public would also be interested in the quality of the work undertaken or goods supplied by the tenderer. Poor quality of work or goods can lead to tremendous public hardship and substantial financial outlay, either in correcting mistakes or in rectifying defects or even at times in redoing the entire work, thus involving larger outlays of public money and delaying the availability of the services, facilities, or goods. Example, a delay in commissioning a project, as in the present case, could lead to power shortages, retardation of industrial development, hardship to the general public, and substantial cost escalation. When a writ petition is filed in the High Court challenging the award of a contract by a public authority or so and so, the court must be satisfied that there is some element of public interest involved in entertaining such a petition. If, for example, the dispute is purely between two tenderers, the court must be very careful to see if there is any element of public interest involved in the litigation. This sentence, my lord, I was relying on. A mere difference in the prices offered by the two tenderers may or may not be decisive in deciding whether any public interest is involved in intervening in such a commercial transaction. It is important to bear in mind that the court intervention, the proposed project may be considerably delayed, etc., etc. What I am trying to lay emphasis on is price is merely one of the criteria. So they could not have ignored the other credentials and given a complete go by to his ability to do the work or not, merely because he has quoted a slightly lesser price. And in any case, you have awarded the contract in part to me at the lowest price. Now, my lord, the second contention that has been raised in the affidavit is that be it for the purpose of issuance of the corrigendum, which the corrigendum itself says that there was a single bid, therefore the corrigendum had to be issued. And even now, when we put this to challenge, as a reason for cancelling the earlier tender process and issuing a fresh NIT, they say that now it will be a single tender. So therefore, we have, for larger participation, we have cancelled the earlier tender process and we have issued the fresh NIT. And this is something, again, they appear to be completely oblivious of the latest CVC guidelines. What had, your lordship will recall, about sometime in 99 or 2000, I don't precisely remember the date, CVC had said that normally if there is a single tender, tender should be cancelled and fresh tenders called for. Now this, many of the authorities, what they started doing is, they started taking advantage of the situation. If they were unable to bring in unqualified people, they started cancelling tender processes on the ground that it is a single tender, relax the tender conditions, exactly what has happened in this case, and issue fresh NITs, relaxing the tender condition. Now, this is the latest guidelines in consultation with CBC, CAG, etc., that has been issued on 29th of October 21. If your lordship will kindly turn to clause 11.8. In fact, my lord, first, if your lordship, how these guidelines have been framed, if your lordship will kindly come to the second page, my lord, para 4, towards the bottom last 4 lines, will indicate the extent of exercise that was undertaken to frame these guidelines.
Which page?
Second page of that, page 2, para 4, your lordship will, line about 5 from bottom of para 4. There is a sentence starting while towards the right hand side. While the primary, as my lord got. While the primary source of these instructions is the draft guidelines prepared by the CBC, the views expressed in the CAG's workshop by Niti Aayog and in other comments received have also been duly considered and incorporated wherever appropriate. So all concerned authorities, regulatory authorities and law enforcement agencies have been consulted. And now if your lordship kindly comes to para 11.8, rejection of single bill. It has become a practice among some procuring entities to routinely assume that open tenders which result in single bids are not acceptable and to go for retender as a safe course of action. This is not correct. Rebidding has costs. Firstly, the actual cost of the retendering. Secondly, the delay in execution of the work with consequent delay in the attainment of the purpose for which the procurement is being done. And thirdly, the possibility that the rebid may result in a higher bid. Lack of competition shall not be determined solely on the basis of number of bidders. Even when only one bid is submitted, the process should be considered valid provided following conditions are satisfied. Number 1, the procurement was satisfactorily advertised and sufficient time was given for submission of bids. Number 2, the qualification criteria were not unduly restrictive. Number 3, prices are reasonable in comparison to market value. So now it is not their case that the NIT was not sufficient adequately advertised. It is not their case that the qualification criteria were unduly restrictive. What were the qualification criteria? The requirement was for supply of 1 lakh liters. So they said that you have to have a storage facility of 1 lakh liters. Aha. Even if they try to defend it, defend removal of those tender conditions, they will have to justify that they were unduly restricted. But no attempt has been done in their affidavit. No attempt has been made in their affidavit to say that these conditions were unduly restricted. And that prices are reasonable in comparison to market value. Now the price, they say, was a price difference, and the respondent number 6 had quoted a lesser price. We are agreeable to do it at that price. You have given the supply order of 4 lakh liters to us at that rate, and we have accepted it gladly. So therefore, my lord, in my respectful submission, looked at from any perspective, this is a case of absolute favoritism, absolute high-handedness. And in these kinds of cases, with all humility, my lord, I'm making this submission. Your lordships will come down very heavily on these authorities. Only for the purpose of accommodating a unqualified, ineligible, a person having no credentials whatsoever. You want to bring him in at the cost of a reputed qualified party. These pilot actions, your lordships, perhaps it is high time your lordship come down very heavily on these. So that is my respectful submission, my lord. These two, the appellate authority never recommended cancellation of the tender. Appellate authority recommended cancellation of the bid. So taking advantage of that, you cancel the whole tender, issue a fresh NIT, completely wiping out all the qualification criteria. This is stretching things a little too far. But subject to what my learned friend says, reserving my right of reply, my lord, that is my submission. I may be allowed to just for 5 minutes.
Well, I'm appearing for the respondent number 224, that is the tendering authority in this case. Lord. So we have filed an affidavit in opposition in the matter, but before taking your lordship to the affidavit, well, just I'll take your lordship, but before that, I'm just replying to the submissions. 2-3 submissions have been made, my lord. Number one, my lord, first of all, lordship may kindly come to the prayer made in the writ petition. What they have prayed in the writ petition, because submissions have been made that 4 lakh liter, 1/3 for supply of 1/3 liter of liquid nitrogen, they have been given an order, and they have agreed to that. That was one of the submission. And my lord, I have the record, my lord, original record is with me, and I'll place the record before your lordship under what circumstances after the cancellation of the bid of the private respondent in the first tender, how the authority has proceeded for issuance of the second tender. That record I have, I'll place that. My lord, page 23 is the prayer made in the writ petition. What they have prayed here, my lord, they have prayed that a rate in the nature of certiorari shall not be issued, setting aside and quashing the order dated 13/1/23, that is the retender order passed by the respondent authority, whereby the tender process initiated by notice dated 26/5/22 was cancelled, as well as all subsequent and consequential actions thereto. Second, they have prayed a nature of mandamus shall not be issued directing the respondent authorities to recall, resign, forbear from giving effect to the impugned order of 13/1/23 passed by the respondent authorities, whereby the tender process initiated by notice dated 26/2/2025 was cancelled, as well as all subsequent action. Then they have prayed that in writ in the nature of certiorari shall not be issued, setting aside quashing the impugned tender process initiated by notice dated 13/1/23 for procurement of 12 lakh liters of liquid nitrogen as well as all consequential and subsequent action thereto. Then they have prayed, writ in the nature of mandamus shall not be issued directing the respondent authorities to recall, resign, forbear from giving effect to the impugned tender process initiated by notice dated 13/1/23 for procurement of 12 lakh liters. Then next they have prayed that a writ in the nature of mandamus shall not be issued directing the respondent authorities to comply with the directions passed by the appellate authority vide order dated 4/1/2023 and bring the tender process initiated vide notice dated 26/5/2023 to its logical conclusion. I am indicating these prayers just to submit before your lordship that nowhere they have said that you have given me an order of supply for 4 lakh liter of liquid nitrogen and you stick to that. I am ready to and that order of supply is 4/11/2022. It should not be cancelled and act upon that order. That is not their prayer. They have also not prayed. In fact, nothing has been stated in the petition or no prayer has been made that as per the appellate order, you cancel the tender of the private respondent that has gone. So I remain in the fray. The order is 4/11/2022. It is in my favor. So not only 4 lakhs, the rest of the liquid nitrogen also you order to supply me at that rate. Well, what the situation is, Lord, after cancellation of the private respondent's bid by the appellate authority, now in the entire tender process, which was initiated on 26/5/2022, the bidder remains is the petitioner, and his quoted rate is much higher, Manoj. Now, if we just delete everything, private respondents, everything, no other bidder, now his rate is there, and if we have to continue with that process, where from the L1 rate of L1 comes, that will be another problem, Manoj. I'll place the record, Manoj, that has been considered. And accordingly, the decision has been taken.
Is it part of your affidavit or not?
Yes, Lord.
Part of your affidavit?
Yes, yes. Lord. In the first tender process, the petitioner has quoted 9.75 per liter. The private respondent, they have quoted 7.25 per liter. So there is a difference of 2.50 to 2.50 paisa per liter. Now the order was issued in two parts: 8 lakh liter to the private respondent at the L1 rate and 4 lakh liter to the petitioner at the L1 rate. If the private respondent goes,
What you are referring to?
Lordship.
You are referring to her.
Malad, I have I'm referring to. I'll take two other paragraphs also. Just kindly come to page 166. That is the affidavit filed by the 224 Malad. It's a part of the affidavit. 166. We have given a comparative year-wise rates of liquid nitrogen supplied to ALDA.
Yes.
From 2014-15, we have shown the approved rate. The approved supplier is PCL, is the petitioner PCL. They supplied the liquid nitrogen at rupees 14.55 per liter. In 15-16, they were the supplier. They have supplied us at 15.30. Then in 16-17, NRL Numaligarh, they come in. They supplied us at 8. Then on the next year, 17-18, the petitioner came down to 8.75. In 18-19, again PCL 7.90. And 19-20 PCL, they supplied us at 9.30 per liter. 2021, 9.50 per liter. Then 2021-22, they are supplying at 9.95 PCL. This, because we could not finalize the tender process, this is still going on. We have to purchase at this tender ballot. Then the next page ballot, 2022-23, rupees 7.25 Meghalaya Oxygen Private Limited, they are the disqualified bidder by the appellate authority. They have quoted that rate. And the petitioner PCL, they have quoted 9.75. This rate was, we did not accept. Lord. At the L1 rate, we have given that particular order. And there is no prayer made in the writ petition that even if the goes and if the process continues, Lord, we are that L1 rate, which is ultimately after cancellation of the bid of the private respondent is nowhere will exist. Lord. We are ready to give that. There is no prayer as such. Lord. Although submissions have been made and Lord, I fairly submit, Lord. And in considering that submission, Lord, I have to take the instructions from the authority. Lord. Without taking instructions, I cannot say, Lord. That is number one, Lord. Lord, in fact, in the second tender process, the petitioner has participated, and Lordship has the technical evaluation has been done, and Lord, pursuant to the Honorable Court's order, Lord, we have also opened the price bid. In the price bid, this time also, the Meghalaya Oxygen is one of the bidder and the petitioner is the other bidder. Two bidders are there. And the Meghalaya Oxygen, they have quoted now 7.67 rupees per liter. And the petitioner has quoted 8.08 per rupees. So my twofold submissions on this that the earlier rate, L1 rate 7.25. They have not, if they are ready to adhere, Lord, even then in the second process, Lord, they have quoted 8.08. And Lord, substantially, Lord, the rate has in the second process again come down. Well, it's a tender process, Lord. This is a procurement contract. We are absolutely concerned with the rate. Price is the main factor, Lord. But Lordship may kindly come to paragraph 3 of our affidavit. And Lordship, I was indicating to the records under what circumstances they have resorted, they have taken a decision for having a fresh tender. I may be permitted to place this.
Is it part of the affidavit or not?
No, record.
We are not generally inclined to go through the records. So they're part of the affidavit.
But the reason we have stated why they have done, but the ultimate discussion, and all these things are there. I
see your affidavit.
Lordship. But Lordship may kindly come to paragraph 3. I may be allowed to. I'll take a Lordship, but before that, I'll like to place this also, because the nature of the contract, and the paragraph 8 kindly for a moment, I'm indicating para 8 and para 9, that specific very Lordship has put. Para 8 is A171. That with regard to the statements made in paragraph 12 of the writ petition, the deponent denies that upon cancellation of the supply order issued to the respondent number 6, the same ought to have awarded to the petitioner. It is also denied that the authorities of ALDA has issued the order dated 13/1/23, cancelling the NIT dated 26/5/2022 in deviation of the order dated 4/1/23 issued by the appellate authority. In this regard, the deponent respectfully states that after receipt of the order dated 4/1/23 passed by the appellate authority, the ALDA has found that the L1 bidder pursuant to the NIT dated 26/5/2022 has been found to be invalid, and in the tender process only one valid bidder, that is the petitioner, remained. the authorities considered that in the interest of uninterrupted supply, L1 bidder was placed order for supply of 8 lakh liters at the lowest rate, and the L2 bidder was placed order for 4 lakh liters at the L1 rate. The total order placed was for 12 lakh liters, valued at rupees 105.48 lakhs as per L1 rate. If the order is placed at L2 rate to the petitioner PCL, the order value will be rupees 159.36 lakhs. And ALDA have to incur excess expenditure of rupees 53.8088 lakhs if the PCL is allowed to supply the entire 12 lakh liters of liquid nitrogen at their quoted rate. Further, the tender process has become a single process without any competitive rate, which is not in tune of the CBC guidelines. Therefore, in such a situation, the authorities has decided to cancel the entire process and invite retender by reconsidering the conditions that more interested parties can participate, and the ALDA may get more competitive rates of liquid nitrogen. The decision for retender was taken to save money and reduce operational cost of ALDA in the greater public interest. Accordingly, the order dated 13/1/23 was issued, cancelling the entire tender process, and retender has been issued in Jan. That is our stand, my lord. Lordship, kindly come to paragraph 3. I will be allowed to read the paragraph 3 onwards, my lord.
Yeah.
But the important information, role and necessity of liquid nitrogen, the item which we want to procure from this tender, my lord, that has some importance, my lord. The necessity of liquid nitrogen on the part of ALDA and circumstances leading to cancellation of the tender, we have summarized here. We have stated that the Assam Livestock Development Agency is a Government of India, and Government of Assam sponsored agency, and it is a registered society under the Societies Registration Act. The basic object of ALDA is to promote cattle and buffalo breeding activities in the state of Assam by production, distribution, and use of frozen semen doses for artificial insemination activities, which are aimed to produce high genetic merits animals for increasing milk production of the cattle and buffalo owned by the farmers of Assam. The ALDA is the state implementing agency for cattle and buffalo breeding in Assam. The Assam Livestock Development Agency is a central government and Assam, the state government funded semi-autonomous state level registered society as state implementing agency created in 2004-5 under Society Registration Act 1860 to implement the centrally sponsored scheme, National Project for Cattle and Buffalo Breeding initially. The main objective of NPCBB was to bring the entire state under the umbrella of scientific breeding and management for economic benefit of the farmers by increasing the productive potential of local breeds of cattle by artificial insemination, that is with frozen semen of superior genetic bulls. Presently, ALDA is implementing a flagship program of Government of India called Rashtriya Gokul Mission. Under this umbrella scheme, 2 programs are now running simultaneously. Nationwide Artificial Insemination Program, Phase 4, with an AI target of 5.9 lakh AI in 10 months. That is August 22 to July 23. And Northeast Region AI Program with AI target of 9.2 lakhs AI for financial year 22-23, that is April 22 to March 23. Then, Malad, we have stated the importance of the liquid nitrogen in the entire project, Malad. Any artificial insemination using frozen technology requires uninterrupted and adequate supply of liquid nitrogen in order to maintain the cryogenic cool chain. The liquid nitrogen is the main prerequisite for preservation of frozen semen at -196 degrees centigrade and can be called as the lifeline of any breeding operation using frozen semen. Physical property and its application in biological works, we have stated below. Owing to its inertness and chemical non-reactivity, liquid nitrogen is considered as the most ideal medium for preservation of any biological material. But because of continuous evaporation nature of liquid nitrogen, a continuous uninterrupted supply is a must for maintaining the levels of liquid nitrogen at any storage storage cryogenic containers used for preservation of biological materials. The AI program for frozen cement dosage prepared as frozen cement straw requires to be fully immersed in the liquid nitrogen at minus 190 degrees centigrade for storage. Under no circumstances, the level of liquid nitrogen in the preservation container can go down beyond the required level, minimum 13.3 centimeter from the bottom. Otherwise, the frozen cement straws get damaged. Continuous and uninterrupted supply of liquid nitrogen is vital to ensure the quality of the frozen cement. Then, Lordship, these are the requirement of liquid nitrogen cattle breeding value chain we have stated. I'll take your Lordship to next page 163. Lord. These are these places. The regional frozen cement pools and their respective districts district-wise number of AI centers are mentioned below. The name of 17 regional FSB and district covered under the regional FSBs with the number of rural AI centers we have stated below. These are the places where the liquid nitrogens are required. District-wise, we have given the list below. After the list at page 165.
Yeah.
To maintain the above chain of events from production of frozen cement, transportation, storage, and finally up to AI service delivery, a continuous uninterrupted supply of liquid nitrogen is essential, without which the state breeding program with frozen cement cannot be implemented. The cost of production of frozen cement straws at FSBS Borpeta near Borpeta Road is normally passed on to the dairy farmers of the state. This will be relevant. The inputs of production includes feed and fodder cost, medicine and feed supplements, egg yolk, rubber and silicone consumable cost, liquid nitrogen cost, chemicals and laboratory reagents, electricity, disease set, important active French mini straws, contract labors, contractual labor, skilled, semi-skilled, unskilled, and biosecurity expenses. Then comes the storage and supply chain management expenditure for doorstep delivery of the frozen cement doses to every nook and corner of the state. The liquid nitrogen at minus 196 degrees centigrade is a medium for production, freezing, storage, and transportation of frozen cement doses, and its uninterrupted supply is a must for the entire chain. The cost of liquid nitrogen forms the major chunk of expenditure in this system, and supply of liquid nitrogen at higher rate may lead to upward variation of the cost of the end product, and it will be an additional burden on the farmers. The cost of frozen cement straws dosage is fixed by the governing body of ALDA, considering all the above from time to time. The last revision took place in the year 2015, and the cost of one frozen cement straw dose 0.25 ml with 20 million sperms is ₹50 at the farmer's doorstep. This amount is the cost recovery. This amount is the cost recovery to meet the recurring expenses of ALDA. Then, Malad, I have already taken your lordship that ALDA has been directly procuring liquid nitrogens from suppliers regularly through tender processes at various rates from the rates we have stated, Malad. Lordship has seen in 14-15, 15-16 rates were higher. Then, Malad, Numaligarh refinery came, then the rates come down. Now, gradually, the rate again the petitioner was the supplier. Rate has just increasing, Malad. Now, again, the last tender process, it has come down. The notice inviting tender dated 26/5/2022 issued by the ALDA for selection of bidder for procurement of pure liquid nitrogen, inviting bids from eligible bidders. The last date for submission of bid was 17/6/2022. The bidders were required to submit online bids at the e-procurement portal, and the detailed bidding documents can be downloaded from the portal free of cost. Till the last date, that is 17/6/2022, only one bidder submitted their bid, and due to single bid participation till the closing date, the authorities felt that the qualification criteria is not supporting medium scale industries enterprises for participation, and accordingly the authorities have decided to relax the qualification criteria to an extent and issued a corrigendum dated 18/6/2022 and extended the last date for submission of bid on 27/6/2022. But this has been referred, Malad. at Lordship, page 101. Time has been extended. It is not that before after the expiry of the last date, the corrigendum has been issued. That is not like that, Lord. I'll just take your Lordship to page 101, just to indicate one thing. In fact, the page 38 notice inviting tender, it makes it very clear, Lord. F, page 38.
Yes.
Learned senior friend has already read, Malad, that the last date, the bid has to be submitted on or before due date of submission 17/6. Then F, bidders are also required to submit hard copy of the technical bid with original document in the office of the procuring entity within due date for submission of hard copy of the technical bid up to 18/6/22. So the hard copy is to be submitted on 18/6. The last date did not expire on 17, Malad. The hard copy is to be submitted on 18/6. So the corrigendum was issued on 18/6, Malad, before the date when the hard copy is required to be submitted. So, Malad, the corrigendum has been issued considering one single bidder, Malad. Thereafter, next paragraph, Malad, at page 167, Malad, that in the tender process, thereafter, two bidders had submitted their bids. That is the petitioner and the respondent number 6. And after closure of the bid, the technical bids of the bidders were evaluated and a comparative statement of technical bids were prepared by the tender evaluation committee on 14/7/2022. The evaluation committee decided to call for 2 shortfall documents from Meghalaya Oxygen Private Limited within 21/7/2022. Thereafter, on consideration of the shortfall documents of Meghalaya Oxygen, the tender evaluation committee found both the bidders technically valid, and by their decision dated 3/8/2022 recommended for parallel procurement of liquid nitrogen from both the technically qualified parties at the lowest quoted rate for operational advantage and uninterrupted supply. That thereafter, the financial bids were opened and the Meghalaya Oxygen was found to be the L1 bidder who has quoted rupees 7.25 per liter of liquid nitrogen without tips. And the Premier Cryogenic was found to be the L2 bidder at rupees 9.75 per liter. Accordingly, the authorities have decided to accept the L1 rate. However, considering the recommendation of the Technical Evaluation Committee, the ALDA has issued 2 supply orders dated 4/11/2023. One in favor of Meghalaya Oxygen Private Limited for 8 lakh liter at their quoted L1 rate, and another in favor of Premier Cryogenics for 4 lakh liter of liquid nitrogen also at L1 rate, keeping in mind the requirement of uninterrupted supply. It is also stated that the Premier Cryogenics is the supplier for the year 2021-22 and for supply of liquid nitrogen last financial year, and their quoted rate was rupees 9.95 per liter. In the tender process in question, Premier Cryogenic has quoted lesser rate than the previous rate, and their quoted rate was found to be the L2 rate. That in the meantime, the petitioner has filed an appeal before the authorities under the Assam Public Procurement Act 2017. And in view of the order passed by the Appellate Authority on 10/11/2022, the supply orders dated 4/11/22 could not be given effect. And the ALDA has been procuring the liquid nitrogen from the earlier supplier, that is the petitioner, at the old accepted rate of 21/22. That in these circumstances, the Appellate Authority by its order dated 4/1/23 held the bid document submitted by the Meghalaya Oxygen Private Limited to be non-responsive and recommended the bid to be cancelled. After receipt of the order dated 4/1/23, Malad.
Yes.
Page 169, Roman 6. That in these circumstances, the Appellate Authority, by its order dated 4/1/23, held the bid document submitted by the Meghalaya Oxygen Private Limited to be non-responsive and recommended the bid to be cancelled. After receipt of the order dated 4/1/23 passed by the appellate authority, the ALDA has found that the L1 bidder pursuant to the NIT dated 26/5/2022 has been found to be invalid, and in the tender process, only one valid bidder existed. After detailed consideration of all aspects, the ALDA authorities have decided to cancel the tender process initiated by the NIT dated 26/5/2022, including the supply orders dated 4/11/22, and go for fresh tender in JAM. Accordingly, fresh tender has been issued on 13/1/22 in JAM. But para 5 law, that the deponent states that, that the clause 4.2.2 of the bid document, which originally provided for the manufacturer of the quoted goods should have valid manufacturing license and experience of manufacturing and supplying at least for 3 financial year ending on 31/3/2022, was altered by the authorities only with the intention of having more participation of tender and thereby increasing the competition. And the deponent denies that the change brought about by way of corrigendum is in violation of the rules. The qualification criteria in the NIT dated 26/5/2022, that is 4.2, was felt to be too stringent and restrictive for allowing competitive bidding, and hence later it had to be relaxed for encouraging wider participation. And following that relaxation, the MOPL, the respondent number 6, has participated in the tender in addition to the petitioner. All other criteria remain unchanged. And all of as regard the quality of the nitrogen and the amount, that those have not been touched. Only some the experience and that has been changed. Right? Then paragraph 8, I have already taken your lordship, my lord. Lordship, they have said the submissions have been made by the petitioner that the provisions have been made that has been changed to favor the private respondent, my lord. That we have denied, my lord. That in paragraph 9 we have said, my lord, that the deponent denies that the condition in the tender notice dated 13/1/23 have been made tailor-made illegally to favor the respondent. In this regard, the deponent respectfully states that the ALDA cannot collect liquid nitrogen from sources located beyond a distance of 150 km by its own tanker for reasons of economic viability. The respondent number 6, MOPL, has its storage and collection point on Abingaon, Guwahati, which is only about 25 to 30 km from ALDA headquarters, whereas the petitioner's plant that is located at Samoguri, Nogam, which is 140 km from ALDA. Hence, the question of favoring MOPL does not arise. We have kept 150 km, and within that 150 km, both the persons, they are having the stations for collection, point of collection. So 150 km has been kept, that there is no favoritism. In fact, the petitioner is being accommodated to participate in all the tenders issued by the ALDA. The allegation of preparing a tailor-made tender document is totally unfounded and has.
Yes, page.
Page 173, my lord. My lord, the para 10, my lord. The with regard to the statements made in paragraph 14 of the writ petition, the deponent denies that cancellation of the entire tender process is in violation of the directions of the appellate authority. And that the same is grossly arbitrary, illegal, and capricious, and utterly discriminatory, and that from the very inception of the tender process, the respondent authorities had attempted to favor the respondent number 6. The deponent further denies that after changing the tender conditions to technically qualify the respondent number 6, the authorities proceeded to cancel the entire process itself when the appellate authority directed that its bid should be cancelled, and that was done even after supply orders had been issued to the petitioner number one company. The deponent denies that the impugned tender process has been initiated by the respondent authority by incorporating a tailor-made eligibility condition and doing away with the earlier criteria in order to illegally favor the respondent number 6. The deponent further denies that any malicious intention on the part of the respondent authority and that by their impugned action, the respondent authority intends to finalize the tender process in favor of a party which does not have means for production of liquid nitrogen in India. The deponent further denies that the respondent authorities have violated the basic principles of equity and administrative fair play, besides also violating the rights of equality guaranteed to the petitioners as well as its directions. The shareholders and the office bearers under Article 14 and 91G of the Constitution. In this regard, the deponent we have reiterated the statements made in paragraph 8 and 9. And we have also said the detailed consideration of the entire matter and in view of the reasons, including the single bid qualification and much higher price quoted by the petitioner, which would lead increase of expenditure of rupees 53.88 lakhs. The retender had to be initiated to bring in more parties to participate. And as regard the Basanta Kolita's presence in the tender evaluation committee meeting, I have specifically taken the instructions on that. Since the ALDA is a registered society, Basanta Kolita has retired on 31st of July. It is an admitted fact. Since the registered society, even not only Basanta Kolita, some other retired persons are also in the society, because ultimately the experienced persons, they are required to run the society, the affairs of the society. They are not full-fledged government employee that the moment they retire and they have no business in the society. On not only Basanta Kolita, others are also some of the other persons are also working in the society. So we have also taken the stand that the entire tender process is a purely commercial transaction. It's purely commercial, and the price of the liquid nitrogen is the prime factors. And we have also filed on the affidavit in reply they have filed, and in that affidavit in reply, some allegations they have brought. We have denied those allegations and filed a rejoinder affidavit. In paragraph 4 of that affidavit, we have stated this is page 250. Paragraph 4. In paragraph 4 of their affidavit in reply, they have stated that they have accepted the bid quoted by the Meghalaya Oxygen Private Limited, that is the L1 rate in the cancel tender process. We said that they were given an order of supply of 8 lakh liters of liquid nitrogen. PCL quoted much higher rate, but they were given a chance to supply 4 lakh liters at the rate quoted by the Meghalaya Oxygen. The orders were placed on 4th of November 2022, but instead of agreeing to supply 4 lakh liters at the lowest rate, PCL went for an appeal and against the qualification of the Meghalaya Oxygen Private Limited, and the PCL did not submit the performance bank guarantee and did not come forward to sign the contract agreement with the ALDA for that 4 lakh. If the PCL was interested to supply at the lowest rate quoted by the Meghalaya Obsidian Private Limited, they need not have waited from 4th of November 2022 onwards till filing of their writ petition and reply affidavit to express interest to supply. In fact, in the writ petition, they have not, there is no prayer to that effect, but I have already taken your lordship to that. In the affidavit and reply, they have stated that we are ready to supply at that rate. So otherwise, they have not shown their interest. They have to give performance bank guarantee for that. If they want to honor, they have not done that and not come forward to sign the agreement, contract agreement also. The price accepted by ALDA was quoted by the Meghalaya Oxygen Private Limited, and the petitioner was only given an offer to supply 1/3 of the total required quantity of the MOPL quoted rate. In such circumstances, disqualification of MOPL automatically cancels the accepted rate. So the question of placing order for 100% quantity to PCL at the rate of MOPL rate does not arise.
Okay, we can resume.
Malad, I am submitting before your lordship that the price is the main criteria for the tenderer, and in the earlier process we have accepted the L1 rate, but that got cancelled. And now in the present process, lordship has pursuant to your lordship's permission, we have opened the price bid in the present tender process. Now the rate has gone again lower. Now they have quoted 7.67 per liter, including GST. The earlier rate was 7.25 excluding GST. 18% GST will be added to that. So this time, the private respondent is one of the party in the GEM. They have quoted 7.67 per liter, including GST. And the petitioner has quoted 8.08 per liter, including GST. It has again gone down, Malab.
I think we are not concerned with that.
Price factor, lordship may kindly, because this is a commercial transaction.
Cancellation of the earlier tender process.
Lordship.
And initiation of the fresh tender. That is the subject matter of the writ.
Lordship.
We are not going into those after what is happening. Permission has been given.
Correct.
We are not sitting on judgment of the second tender process. We are whether initiation of the second tender process
Is correct.
by the NIT
Correct.
is proper or not.
That is basically the
We are-
challenge. That is basically its challenge.
We are on that.
Lordship.
What is the outcome? That is not for the court to decide. It is for the tendering authority. We are not prejudging it.
Correct.
So we are not going into that aspect. You
I have-
you have been asked, you have been permitted to open.
Lordship.
You have opened.
Lordship,
We are not deciding it because they are also not doing, going in that manner. The petition, prayers you have read,
Lordship.
is validity and legality of the cancellation of order.
And
The
the
first tender process
correct
and initiation of the second
process.
tender process by the
Madam.
press and IT
Madam.
in the backdrop of the cancellation of the first tender.
Correct.
Those are the issue.
That is the main
Since
issue.
it was initiated, they wanted to stay the second tender process. So on that basis, interim order has been passed from time to time,
Not to finalize the process.
not to.
In fact,
We are not going into that aspect that this time they have quoted, this time they have.
But,
They are saying in the second tender process, in the NIT, some changes have been made to bring in the another bidder, that is the private respondent, and the tender clauses have been made tailored. That is what their
That-
submission.
that is,
We are not going into the price aspect.
but,
After opening, you have been asked to open.
Lordship,
I don't know. This, we are not going into that aspect.
this is a relevant consideration in my respectful.
Or
submission,
you.
my lord.
We are not sitting on it.
Lordship. But, Lordship, as regards the,
If suppose this petition is dismissed, suppose, then you are free to conclude the
process,
second tender process.
Lordship,
Then they are also free to challenge it again.
it's a different-
Suppose changes in the clauses are held to be okay, then you are free to go ahead and conclude the tender process.
Correct.
Then they will be free to again, they will have the cause of action to challenge it again
Lordship.
on other counts.
Well, in fact, my lord, under the circumstances under which, my lord, the tender has been cancelled and fresh tender has been issued by
That
JAM,
is-
that we have placed, my lord, and the record also I have placed before your lordship.
So
That is
these
the
rates,
consideration.
we are not going to take cognizance.
In
This, in the second tender,
lordship, I leave it to your lordship,
I don't think we should travel beyond the, what is
the challenge.
the scope that it.
Now, in fact, that is why, my lord, I have submitted before your lordship that what they have, my lord, what they have submitted. My lord, on one hand, my lord, they have stated that I am ready to go by the L1 rate of the earlier tender process.
That is,
L1 rate will not remain after cancellation of the private response.
that submission is that,
Lordship. So
that
the,
submission is permissible.
so the rate quoted by them is the only available rate, which is much higher.
Okay.
That is one of the consideration for going for the retender. And that is the stand taken by us that in fact, in some other cases also, Lordship, for the invalid bidder, invalid bidder has quoted the lowest bid. And Lordship, the on that ground, because we are not going to, well, ultimately it will go to the farmer. The public money, I'll
Yes,
take the Lordship.
yes. We are only up to the initiation of the second tender.
Lordship.
application,
Lordship.
Right, with modified clauses.
Correct.
Right,
Correct.
we are not
And
going further
my lord, the
beyond that.
Lordship.
So whatever is quoted by these two bidders, that is not the scope of the repetition, I am saying,
my lord,
right?
and another
We
thing, my
do
lord,
not have to deal with that.
another thing, my lord, it is also important, my lord. In the second process also, they have taken part, my lord. In one hand, they have taken part, and on the other hand, my lord, they are challenging the retendering thing. That also, Lordship, needs to be considered, my lord. My lord, the one submission has been made, my lord, that the
When this repetition was filed,
this petition was filed in the month of February 22.
Hmm?
February 22, my lord.
what is the last day of the second tender? Second NIT dated
13/1/23, my lord.
13/1/2020.
23.
When was the last day?
And in the GEM portal, it is 1 month, my lord.
Really? I take it.
I may take it. Page 149,
Date.
page 149, my lord.
Date.
13/1/23 is the date. Last end bid and date is 3/2/23.
The
2/23.
When the repetition was.
They have signed the affidavit as per my copy, my lord, given copy on January, my lord.
21st January 23.
20,
1st January 2020. It was discussed for the first time on 25th.
so before the last day.
Before the last date, they filed the repetition.
Hmm.
And ultimately, they took part in the process. Well, page 65 of the tender condition, that is one of the condition that has been changed. 4.2.3
Hmm.
A,
4.2.
4.2.3
Hmm.
A,
Hmm.
this relates to the storage capacity.
What is the new one?
The bidder must have own production plant or bulk storage facility, minimum capacity of 1 lakh liter per month in Assam. And
The next one, what is the?
in the next tender,
Capacity is missing.
capa-
No whisper about capacity.
at page 155, Lordship will find the delivery and completion time. This has been stated. The procurement quantity will be 12 lakh liters during the contract period or more from the date of signing of the agreement, which may vary, not exceeding plus minus 25%, according to the actual consumption by the user institutions located throughout the state of Assam. Weighbridge reading will be necessary before and after transfer of stock to empty transport vertical tank of procuring entity. Conversion rate will be 1 kg is 1.236 liter. Acceptance of conversion factor reading shall be limited to maximum net capacity of volume.
Experience criteria is also missing. Experience criteria.
Malad, what I would like to show, Malad, that they have put clauses to ensure timely and uninterrupted
No,
supply.
I'm
That is the
asking,
point. That is the point.
experience criteria has
Logic.
been done away with.
Malad, in
If we compare page 65
logic.
with 155, that capacity, storage capacity, that is gone. Secondly, last 3 financial years experience or supplying 1 lakh liter quantity per month during last 3 years, that is gone.
Logic.
Then details of supply of similar product experience, that is gone. Only 155 qualification of bidder
Logic.
is capital A. Right?
Capital A, yes. Location of plant storage facility collection points should not be more than 150 kilometer from the operational headquarter of ALDA at Khanapara location plan, storage facility collection point should be mentioned by the bidder. So they are required to submit now how they will give us the uninterrupted supply, my lord. And for that, there is an indication at page 102. Page 102 is although this is the comparative statement of the earlier process, my lord, just an indication in the record lordship, the other materials are available. My lord, just for a moment, my lord, I am indicating page 102. In the retender, my lord, provisions have been made for
What
There-
are the documents required to be supplied by
It-
the bidder at the time of submitting his bid in response to the second tender notice? Because in the first one, there are many things. Just some, say for page 50,
say
certificate on financial strength. As per so and so.
page 151, there is an indication. This is a JAM. It was published in JAM.
The indication is defined in
Yes.
tender document. We are examining tender document.
Specification document, the view
What are the
file.
documents? In the second tender process, one has to say in the first tender process,
My lord,
let us see the first tender and document.
it was mentioned.
Page.
It was not published in JAM. Lord. The first tender was not in JAM. The second is in JAM.
Just maybe gem or whatever. Say 47. $2.5.
Gotcha.
You have laid down some eligibility.
Gotcha.
Then 2.6.
Qualifications. Gotcha. This was in respect of the earlier tender. My lord. Then
Earlier,
then documents are mentioned.
then 49, document comprising the deed. So many documents, about 16 documents.
Gotcha.
Or see, all this
Hello.
up to Roman 16. Then Roman 17 is checklist of document submitted along with the bid.
Gotcha.
There you have listed about 17 documents, maybe more also. Because you have stressed on small, medium enterprise, something like that, while cancelling or while issuing the corrigendum. While
Gotcha.
issuing the corrigendum, you have stressed on the factor that more small and medium enterprises should come in.
Because at that point of time,
Right.
only one bidder, petitioner was
Right.
only there.
Now,
Lots.
page 50, you ask for valid registration certificate from DICC, that Udyog, Udyam, whatever is. Then page 51, 2.15. Then 2.16. All these were stricter. Now, What are the only, this is the requirement now. Is this the requirements that document starts from 154
Page 150, Lordship,
or rather say we start from 150?
page 152. From page
Page 149,
lo- one
149. It starts from 149.
149 it starts,
It starts,
Lordship.
so where are those conditions?
Page 152, kindly see the terms and conditions,
52, let us see.
Lordship.
What is ATC?
Lordship,
ATC.
there is a clause at page 149, document required from seller. There also it is there
Where are
is
those documents?
additional terms and conditions, my lord.
Where are any list?
Additional document requested in ATC, additional document 2 requested in ATC. This there is a mention in page 149, my lord.
Hmm. Requested in what is ATC?
Additional terms and conditions.
Where are those?
Those are at 153, my lord. There is a clause disclaimer. There lordship will find.
Hmm?
One at page 153, the additional terms and conditions have been incorporated by the buyer. The GEM portal is already there, my lord. These are the additional terms and conditions have been incorporated by the buyer after approval of the competent authority in buyer organization, whereby buyer organization is solely responsible for the impact of these clauses on the bidding process, its outcome and consequences thereof, including a certainty restriction arising in the bidding process due to these ATCs and due to modification of technical specifications and or terms and conditions governing the bid. Any clauses incorporated by the buyer regarding following shall be treated as null and void and would not be considered as part of the bid. The definition of class and class, so these are the
Where are the documents? No documents required. Where are those clauses? Because 155 simply 1A, capital A, small Roman 1. That's all. As I have shown, indicated to you in the earlier process, at least 16 number of documents were required to be submitted by the bidder. Now, clause A does not require any document. Clause A only one document. What about the eligibility?
in support of that, my lord, location of plant storage, definitely they have to give document.
Right, but what about all those 16 documents? Have been, everything is done away with.
No, it is
Where are
not,
those?
it is not done away, my lord. It is not done.
Where are those documents? You might have in the records also. If we go by this tender document, only one A, capital A. Unlike so many details in the earlier one,
Page 65.
which starts from page 38. It might be hidden in the portal also, we do not know.
That may be, my lord, that may be.
Otherwise, that only that thing that 4.2, page 65. If we go by only page 65 has been relaxed.
My lord.
Page 65 has been relaxed by page 155. That is your submission. But where does the other things reflect?
Well, in the portal, where is that
You might be-
mentioned?
You are the man who can answer.
Correct, my lord. Just in the online portal, my lord, where it is, just I'll inform the court.
But all those were also done with.
No, conditions,
Then, that will be different consideration.
I'll satisfy your lordship, my lord, to that. My lord. Because documents,
It will be in existence or not in existence.
it is there, my lord.
Only simple thing.
It is there, my lord.
You are not finding it in your this whatever is annexed by the petition.
Lordship.
That whether second document, second tender process is annexed with your affidavit.
No, the gem document would have
Only
been there.
first one has been annexed. Only first. You have annexed the first one only.
Yes,
Or you can go through it might be there here.
office notes and others are there, my lord. I'll just verify.
Because 65 has been relaxed by page 150. Okay. But even all the other criteria, terms and conditions are also deleted. Then it's have to see from another perspective.
Lordship, may give me 5-10 minutes time, my lord. I'll just go through the. It is with us.
Earlier one is physical or what? Not in e-tender,
No, it was not at e-tender earlier. Earlier it was not e-tender.
not e-tender.
No, my lord. Not in jam.
A seal with single bit shall be followed. Accompanied by. Which must be submitted online. First one also,
Online,
page 38.
online and the hard copy has to be given also.
Ah,
no?
hard copy
It
has
it
to
is
be
it is
given.
not it is not in the government e-portal, my lord. government-
E-procurement, right?
Government,
Some tender.
government, no, my lord, in Assam tender website, web portal, it is published. But now it is government e-marketing, GEM portal is different. my lord.
Right, but earlier one
In-
also,
In Assam tenders, it was published. Assam tenders contains
no,
tender of
come
all.
to page 30,
Lot.
38. E,
Lordship. Bid must be submitted online at the e-procurement portal, that is assamtenders.gov.in on or before the due date of submission, that is up to 17 June.
Hmm.
Then F lordship will find F
That is hard copy, but
hard copy,
bid document should be same.
same.
If you are also doing in e-portal, come to 104.
But GEM portal is different, Mulad.
Okay.
Government e-marketing is a different portal.
Jam portal, just because jam portal is different,
Gotcha.
all these criteria, whether they were in existence or not. in
Those
existence.
are in existence, Mulad. Definitely they have to be. They have to be.
As on,
I'm sorry to interrupt, but my specific instruction is that the second tender, it is the complete, when we go to the website, this is the complete set of documents available.
I am asking Mr. Nath, suppose Mr. Chaudhary, just I'm asking because how, to what extent they have done it? Say for
Nothing is there. If your lordship sees, compare page
Suppose
65.
come to page 49.
Mine.
That preparation of bids, documents comprising the bid,
Mine.
all those manufacturer authorization, detail of supply in particular format,
Mine.
right? Say page 50,
Mine.
certificate on financial strength,
Mine.
right? All those has some relevance.
Exactly.
So whether in the second tender process, whether these were in existence or have been done away with, that is what I am asking.
Totally.
If these are also done away with,
No, these are
oh
not.
no, we do not know.
Lordship.
But they are changed, that clauses are changed to accommodate. If it is only limited to page 55 versus 155, it is okay.
65 and 155.
155, oh, sorry,
155.
55, 65, I'm
Yes, sir.
sorry, 65 with 155.
155.
That is regarding this thing, having storage capacity, 3 years experience, 1 lakh liter. But all other this financial solvency, something, all have been done away with or not?
But my instruction is not, but I have to ultimately show.
You have to be
Not,
sure,
correct. It is not the
not in the part of the case.
correct.
We cannot say.
But it is not because
As Mr. Chaudhary is saying now that it was not part of the second.
Even
no, that is.
when
in
we
fact-
download, we are supposed to ultimately, we download these copies from the web portal.
We are not fully accepting your statement, subject to correction by Mr. Nath.
Logic. In fact, Mulad, only
He has claimed now. So you have to rebut it.
I have to.
That's all.
Yes, sir, I have to. Otherwise, Mulad, every ABC will come and participate. Mulad.
Huh?
That requirement has to be there. Mulad.
Something has to be there.
It is there, Mulad. It is there.
Because we are seeing a document
Logic.
which starts from page 149. It is hardly 49, it ends at 157. So hardly 8 pages.
Logic.
I don't think 8 pages. And if we say 156, 157, all those are after award of contract, opening, evaluation of technical bid. So documents must be prior to that,
Logic.
which I have not.
Mulad,
Say
def-
page 54, 154.
yes,
Let us see, let us.
I have seen. Since they are also, Mulad, this is a 2-bit system, Mulad, their documents has to be there, Mulad. I'll just get the instruction and I'll place it in the logic.
We can start at 2 then.
Not,
You can, in the meantime,
yes, Mulad.
get the instruction.
Yes, Mulad. I'll get it.
Because everything is gone, then there is a difference.
No, that is not, Mulad, because otherwise every ABC can
Right.
come and participate.
So,
Mulad.
that is why I'm giving you.
Eligibility has to be there.
Get the
And
instructions.
And that much relocation has been done. It is the case of the petitioner also. Petitioner has also not said that no document at all is required. Everybody can come and
But they
participate.
have made a case that they have. tried to
Qualifying
make-
criteria itself has been like.
Clauses have been so relaxed to and tailor-made to accommodate respondent number, private respondent.
It is there.
It is what their case is.
It is there.
So to that extent, we can see. 2 o'clock.
So-
starting. Mr. Dotto, you have to add anything? Beyond that, then we can hear you till 1 o'clock.
My lord, if your lordship is restricting the matter between, my lord, the cancellation of the bid and the fresh one. Up to that, my lord, it is the area of my learned friend. And to that, my lord, possibly I cannot say anything because I doubt whether I have the locus.
No,
But my learned
I
friend has said,
am saying, considering a prayer meet, what I have been saying, that we have to see whether we are testing the reasonableness of cancellation of the first tender process
yes,
in the backdrop of what have been projected by both the parties. And the threshold of issuance of the second fresh tender process. And from by interim orders, the tendering authority has been allowed to go stage by stage.
yes,
We are not examining what are the rates, what are not the rates. That second process after initiation, because we are examining the second tender process because of the challenge that clauses have been incorporated or deleted to
accommodate some.
accommodate or relax to such an extent. This is what happens if the writ petition fails. The tender process would go. Thereafter, on the basis of the tender clauses or whatever, they have the option to challenge again, or you have the option to challenge again. We are not. What price you have quoted, what price Mr. Chaudhary has quoted in the second tender process, we are not going into that.
That is not an issue.
But then my learned friend argued much against me that whether I have the capability or not. My lord, this is a totally imaginary grievance.
Which one?
It is a hypothetical case that I do not have any eligibility. I do not have any capability of supplying. There may be disruption of
he
that.
That has attained finality because the appellate
He's-
order is not
he's-
under challenge.
If I have understood correctly, his submission was structured on the basis what were found out during the first tender process.
Yes.
What were found out during the first tender process that bid evaluation, technical bid evaluation committee, how they have considered the shortfall, then made you eligible, then proceeded further, then appellate authority decided cancel his bid, they accepted it. Plus, they have gone one step ahead, cancel that. I think that in that line, so,
Appellate authority order is final.
so
His disqualification is final.
I think that appellate authority order, you are quite aware of.
My lord, yes, up to that, my lord, we don't.
I have not challenged
My
that.
lord, we haven't challenged also.
So we are confining to that.
Up to
And-
that area only.
Yes, to what extent the second tender process initiated by the NIT with relaxed clauses, permissible or not permissible? We will not go beyond that.
My lord, what I understand, I have seen the necessary papers what were with me. Just to, my lord, giving a wider participation, that clause 4.2.2 was relaxed. Up to that, my lord, possibly that,
We are looking at that, but since documents we have seen,
yes.
that is why I have made the query to Mr. Nath,
Right.
whether all other things have been done away with or not.
No, that cannot be, my lord. The government must have those
I
records.
am not jumping to the conclusion.
Right.
I have asked him only.
My lord,
Saying is another thing,
yes,
seeing is another thing.
right. That's true, my lord.
Right? Saying and seeing are two different. So we like to see.
If my learned friend restricts up to that, my lord, possibly.
I don't
only-
think we are not going beyond the first NIT. That will be another battle perhaps, if he fails.
Yes.
If Mr. Chaudhary fails in this stage, then that will be another battle. On the basis of the terms and conditions incorporated in the tender notice, second tender. Notice. That will be another battle perhaps. We are not going into that. Is it not my scope?
That's,
Whether it is beyond that, my scope of this petition,
that up to that much only, my lord.
that much. So that much only.
Yes.
Yes, then anything to be added.
My lord, if beyond that, what my learned friend argued, that whether I'm having the capability or not, possibly your lordship will not go into all that. If-
We are looking at the condition, how far it has been relaxed
Right,
in the
your
second.
lordship is up to that one,
Only up to
right,
And because some things are on record in the first tender.
yes. That's fine,
Because we are not examining what documents you have submitted and Mr. Chaudhary has submitted pursuant to the NIT, second NIT.
so this is up to the authority, my lord, they are the
That's it.
expert, they will look.
We are
at
not
that.
prejudging it.
Yes,
But if the tender notice, suppose second NIT is set aside, then everything goes.
yes. Your lordship will look into all that.
So that is all. Yes, Mr. I have just, because you have taken me through the affidavit, one more thing. I have found one thing more strange. With opposition. You have filed two affidavits, right?
One resigner we have filed.
Somewhere I have seen one thing. I just want to ask you.
May I know, as regard.
Can we join the page 253.
Lordship.
Why you are required to make those statements? The petition has been trying to monopolize, have always tried to persuade purchaser organization like ALDA to include restrictive clauses in the tender document that would automatically debar other suppliers from participation in the bids. But then, in view of this, ALDA decided to remove all restrictive clauses. Indicates all restrictive clauses were incorporated by ALDA on earlier years at the instance of, or at the behest of the petition. The meaning that can be inferred this statement. Are you as a tendering authority being dictated by petition?
No, my lord,
Read.
no,
It will be
I have read, my lord.
So read
I have read.
the meaning that comes out from reading this statement.
My lord, the authority found that some of the clauses are restrictive, then, and that is why, my lord, no other participation is there. That is why they have said that those clauses are very strict and stringent, my lord, then those they want to relax. And now the petitioner in this.
That doesn't have always tried to persuade the passenger organization like Allah to include restrictive clauses
But they
in
have-
the tender documents.
Look.
That would automatically debar other suppliers from participation in the bids.
But-
In view of this, Allah decided to remove all restrictive clauses.
It was, but they are indicating at the time of issuing the corrigendum. Because the corrigendum was issued and they have indicated to that, my lord, that the corrigendum has been issued to favor somebody. But we said that since there was one bidder, we have relaxed the clauses, so the restrictive clauses
No,
are being come.
Now I have understood the table you have taken me to
Lordship.
with this statement. I could understand.
Lordship.
Anyway, but that for a tendering authority to say that you have incorporated perhaps the meaning that comes out.
But,
As if the restrictive clauses were incorporated, perhaps at the instance of.
No. In fact, the clauses as has been incorporated have become, my lord, strange.
Anyway,
That is why they have been relaxed.
Mr. Rato, you have nothing to say.
Yes.
2 o'clock.
2 o'clock. my lord.
On that, my lord, on that paragraph, your lordship will kindly
Will
see
come at
how
two.
it has been sworn.
Huh?
How it has been sworn.
What?
Sworn through the knowledge of the person. It is not born out of record. So it is one person saying that I tried to influence them to include restrictive clauses.
No. Not to incorporate, but to keep. Because the, I'll submit. my lord.
No, because you're in view of this, that word is not properly chosen.
Lord, my learned friend said, see, I do not have any explosive license and all that. These are not correct, my lord. I have incorporated in my affidavit. Your lordship will find from paragraph 2, page 276 onwards. All the documents we have.
Okay, we'll proceed. Then required, you can answer.
My
Oh. Coke. Finish with Coke. এটা 130 মানত আহিব তাতে
Environmental consent নিদিলে তোমাক কৈছে তোমাৰ এইটো মোৰ বিৰুদ্ধতে লিখিছে সেইটো কাৰণে বেলেগকে এটা স্পেচিফিক প্লেন কনস্টিটিউট কৰা গৈছে মই এতিয়া consent দিলে দেখাত বেয়া দেখিব নহয় মই তোমালোকৰ কথা হ'ম বুলি কৈছে কালি আগতে APSC মই ক'লো আৰু APSC মেথড কেইটামান ফিক্স আছে আলটিমেটলি গৈ নহ'ব
মই এডিশনত আমি বাদ পাই আছো মই কেনেকে
নামানেই নহয় কোৱা কথা তাত কিন্তু বেয়া নহয় একোৱে নামানে
ভয় দে কোৱা Sound. এইটো তুমি এইটো অলপ লৈ লোৱা মানুহ মাতিব লাগিব দুটা বজাত মান ল'ব লাগিব জেমত কি ডকুমেণ্ট দৰকাৰ সেইটো মোক লাগিব
Yes.
Well, as regard the GEM, the platform, I have taken the instructions. But the GEM is a platform where the suppliers or the dealers they are already pre-registered. The qualification prerequisite for GEM seller, service provider, registration and profile update. That guideline I have given. That is the platform where the one dealer, whoever deals with a particular subject matter, the item, he has to be registered there, and his business details, profile, personal details, Aadhaar number, GST, all these things are already registered there. Now, if the government organization want to procure or anybody want to procure for the GEM portal, in this case liquid nitrogen, then we will give the requirement for procuring the item. Then whoever is registered for and dealing with that particular item, it is open for them to participate in that process. So therefore, the required information, the PAN numbers, date of incorporation, business organization, where they locate, and all these things, those are already pre-registered. Those things are no longer required.
So according to you, tendering authority
Not.
does not lay down any qualification criteria.
The eligibility criteria, which was earlier in the tender, that the GST registration, financial things, all these things, all these criteria in the GEM portal, since they are already pre-registered in the platform, and now that it has been made mandatory that for any procurement we have to go to the GEM portal, and if the item
In
is
the
not,
GEM portal for nitrogen, liquid nitrogen, it is there.
that item is available there.
Huh?
If the yes,
Available.
it is available, and in the same portal, the petitioners also participated in the tender. They have also taken part.
Right.
Yes,
You are not getting my point.
liquid nitrogen is available there.
Available.
Yes.
So, query is
Logic.
that once the bidders are asked to participate through GEM portal.
Logic.
So tendering authority is not required to lay down any qualification criteria or eligibility criteria. That is what your contention will be.
Logic. The terms and conditions.
This is a submission, my lord. Let him put it on biddings. Because in the GEM portal, there are thousands of tenders where qualifying criteria are laid down. This is out and out incorrect false statement being made, my lord, without
That is
affidavit.
why, because it will be.
No, this
quite-
is not a false statement, my lord. I have on the basis of the instructions and that I have taken from the
Because
authority, I'm making this
we
submission.
don't know about what
But-
criteria is set forth, but otherwise in the first tender process,
Got you.
some norms are laid down, right?
Terms and conditions are there at page 155. But I have also asked them whether these are the two
These
only.
terms and conditions is one thing, 155, I am.
But I have also asked them that whether these two persons are only available who is dealing with the liquid nitrogen. Well, there are other persons, in fact,
Right,
who is dealing.
155,
Logic.
because B, capital B is
Logic.
regarding the what kind of liquid nitrogen you want,
Technical specification.
right?
Correct.
But so far as eligibility criteria is concerned or qualification criteria, whatever,
Malat.
it is only capital A,
Capital A.
right?
Correct.
So if we look back
Logic.
to first NIT, there are many things which have been laid down, right?
Page 65,
At
Logic.
least page 49,
page 65 also. Mainly
page 49 also.
Yes.
Documents comprising the bid,
Logic.
this 2.11, right? All these are required, say certificate on financial strength. That is also one part which is
Logic.
required otherwise.
Logic.
Then if you come to other criterias, say for example,
Self-attested PAN,
say for 62,
bidder certificate
written
of incorporation.
corporation, say proprietorship, so and so documentation, original power of attorney, certified copy of board resolution, all these, right? Then if we go to say page 64 onwards,
Logic.
those are more. But starting from 49, all these are part of the, should be part of the bid document, right?
Correct.
And since your declaration for the corrigendum is, say, small and medium scale promotion.
Correct.
So 50X is also required registration of district so and so, because they will get price preference also.
But that was in respect of the corrigendum of the first standard.
So where are all those gone?
But
Because
now,
we are into tender clauses, right?
Matlab, as per the JAM portal, now they are pre-existed, Matlab. They are already available
I
there.
don't know. Don't know about that. Pre-existed or not. You have to show me. This document does not indicate.
But can you see
It
the
says
Logic.
Aadhaar card, mobile number, email ID,
yes,
business type, address details, bank account details,
Logic.
right?
The required information mandatory, kindly see the next page.
My lord, I'm sorry to interrupt.
I'm-
After page 49, if your lordship will kindly come to page 51 from. Those are not the only documents. Page,
I have just indicated.
page 51, down below it. 2.16. Documents establishing eligibility and qualification of bidder. Page 51, bottom.
I have indicated to Mr. Nath. that
Yes.
These are few documents which
Yeah,
are
exactly. All
part
of
of
this.
the
required.
first bidding process.
2.5.
Whether only out of the first bidding process, whether only page 155 capital A has remained or something else. Are you having an idea
Matlab-
why I am asking you?
Matlab, correct. Matlab, I have taken the instructions, Matlab, that while going through the JAM, whether the requirement of page, whatever indicated at page 49, those still are required or not. That instruction I have taken. Matlab.
Furnished
Logic.
does not indicate, right? Because liquid nitrogen may be there. I don't have any idea.
Logic.
So if liquid nitrogen are there and for it getting the tag of a supplier for liquid nitrogen,
Logic.
few things are required in the GEM portal. If both of them have done, then what are those?
Matlab,
Because if every clauses have been done away with
as
from the
regard,
first tender process,
as regard eligibility of the bidder.
whatever documents, financial
Logic.
documents, you ask for all those in the first tender process.
In the first, we have asked.
Right. Now, where are those? Because second tender process, the documents are before us. From 140
Yes, my lord.
something.
Yes,
One.
only the terms and conditions A, Lordship has indicated, my lord, that remains,
Page 155 only.
Lordship.
So if all those have remained, then only we have to see clause A.
Correct.
That dilution of clause A. That planned storage facility collection point within 150 kilometer from Alda.
Lordship.
You have done away with 3 years experience, 1 lakh per month
Lordship.
experience, all those you have done with. That is regarding experience,
Lordship.
right? But what about the other documents required to be submitted, right? Because if you say, come to, again, I am 49C. Just for an example, I am
My lord.
say page 49, last one. Earlier, it was details of supply to government department. Now you have said that is also has been done away with.
Lordship.
Page 50, Roman certificate on financial strength.
Stand.
One has to have also strength to supply. Say, for example, X, valid registration certificate,
My lord.
right? 11, documents establishing the compliance to the required quality standards of the product offered. Right?
Lordship.
All those have been done away with. If it is really done away with, then that matter is to be looked from another perspective.
But in fact, in true sense, my lord, these are not done away, my lord. And in fact, what has
Two
happened?
sense means I have to
Lordship.
be satisfied from the documents.
Right. My lord,
Right.
my lord,
Just I am
a
asking.
particular entity is registered under the GEM, my lord. GEM has registered him, he's a registered my lord, entity. So this registration certificate is not, it has not suffered. And the certificate of incorporation, PAN card, GST registration, all are already, they have already complied with that and got the registration in the
So
GEM.
now better you come up with concrete things,
Not too much.
because if these are also done away with, then there is another matter. And if these are not done away with, we have to look from the because the tender jurisprudence is limited otherwise.
Lordship.
But they are saying that clauses have been tailor-made in the second tender.
No, but if it is, my lord, it will be tailor-made, my lord. If while issuing a tender for GEM also, those are required, but that has been left out because only for the
Because
purpose
how
of
we
favoring
have
correspondent number 6.
done the
In that,
tender technical bid evaluation, I have seen.
Lordship.
That is why I'm asking you,
My lord.
you can find out
If Lordship.
liquid nitrogen for registering yourself to be a supplier of liquid nitrogen
Lordship.
in the GEM portal, that all these requirements are to be met,
Correct.
right? Then it is okay.
Correct.
But if it's nothing, only by PAN, Aadhaar, you get yourself registered as a supplier of liquid nitrogen. And the tendering authority is not laying down any eligibility criteria, qualification criteria in the GM portal except 155. It's something I have not come across.
Lordship.
I have not come across.
But my lord,
Quality of the product, okay, we need this product. 99.9% purity,
Lordship.
liquid nitrogen.
Correct.
Okay. But what about the capacity, financial strength? You have done away with the experience also. Right? So what is the capacity or what is the financial strength? What kind of entity? If these all are required to be complied with for registering oneself in a GM, okay. Just get me that document.
correct. Well,
Otherwise,
as per my telephonic conversation, these documents have been sent to me. I have taken the print of, I'll clarify.
Let
get-
him place
I'll
it by way of an
get-
affidavit.
Yes, yes.
See,
I'll get
they
that.
can say
I'll get
on anything. Ultimately, decision is to be taken by this.
Let him place it by way of an affidavit so
Yes,
that we can
yes,
also respond to it if necessary.
Yes, yes.
No, if he comes up with saying that nothing is required. No required affidavit. Okay. Because I have seen, I have handled GM tender also. But the prerogative of laying down the eligibility criteria and qualification criteria is of the tendering authority.
Exactly.
Right. I have seen many.
I'll
So this is the first time I have heard. That is why I'm asking you.
I'll definitely, I have to be doubly sure. I'll
Sure.
check. I'll
But
check.
I have come across many tender processes where the prerogative of laying down the eligibility criteria and qualification criteria is of the tendering authority. They set the norms. Then thereafter the game begins in the GM portal.
I'll look into it. I'll verify.
But here your submission is that GM portal lays down the norms, thereafter the play begins.
No.
Sir, the name, if your lordship sees.
I respectfully submit that just telephonically what I have.
Right, that I'm giving you
I have
an
got.
opportunity.
But
Maybe on
that-
Tuesday next week.
since the person is, since the dealers are available in GEM portal, we have uploaded it and their registered tenderer has responded to it. That is
See,
what
Mr.
I'll
Nath,
verify.
Maybe a liquid of,
I'll
maybe not, may not be a rocket science also. One, we have seen, we come across newspaper reports, he is preparing in the backside of his house. Right, psychotropic substances, underground rooms are built. People are manufacturing medicines. Right, giving mark, sign, whatever. All these big companies, Rainboxy, preparing. This is not that. So I want to know that.
Just the impression given to me is that since
Okay,
whoever
Tuesday,
available, Tuesday, madam.
Tuesday.
Yes,
Other things are hard, only
Logic.
this thing.
madam.
It is only 155. Or something more than 150.
Logic.
That's all.
Yes, yes.
Okay. I
In that
heard-
case, my lord, may I suggest this? Let him file the affidavit on Tuesday. If necessary, we'll file a short reply on Wednesday. Your lordship will have it on Thursday. That will save some time. Otherwise, unnecessarily, we'll come up and again ask for some time.
Logic.
দুইটাই কিমান আছিল ন? চাৰিটাকে লেখি আছে নেকি?
Tuesday is
Tuesday is third.
third, madam.
So if he files the affidavit on third,
Sorry.
we can respond if necessary on fifth,
Keep that.
by the next day.
Okay, we'll post it on 5th.
Fifth.
Madam.
I need not have to say anything. Or I have to record.
Lordship may indicate, madam,
Okay.
that the
Heard Mr. I. Chaudhary, Learned Senior Counsel, assisted by Mr. Pidas, Learned Counsel for the petitioner. Mr. Dinath, Learned Senior Government Advocate Assam for the, who is there? MS Kotoki, Learned Standing Counsel, Agriculture Department for response number 1. You need to make any submission? I am closing opening part. Reply will remain. His submission will remain.
correct. Gotcha.
Do you want to make any submission?
No, my lord.
No.
No, my lord, we have already cancelled the first bid actually, my lord. I'm for respondent number.
Do you
1 and
add anything to what Mr. Nath has submitted?
Oh, my lord, I will file one affidavit, my
Oh,
lord.
no.
Give us some time.
No affidavit. Do you want to make any submission
No, my lord.
or want to add any submission other than what Mr. Nath is submitting? So I can say.
Well.
Okay. You will adopt the submission of Mr. Nath.
My lord.
Okay. Mr. D. Nath, Lanet, Senior Government Advocate Assam, order as per number 2 to 5.
2 to 4.
Should I keep it something for you?
And for response number 6.
You have submitted.
My lord, let us see what is forthcoming.
Okay. Mr. Nath, during the course of his submission, has submitted, and that the procedure regarding registration of a supplier in the GEM portal, he will place the he will place the information. He'll obtain the information regarding the procedure for registration in the GEM portal as a supplier of liquid nitrogen, and the eligibility stroke qualification criteria, if any, required for such registration.
Or kindly indicate, my lord, that whatever eligibility criteria was in the first, what are the criteria they have adhered in the second? That indication.
And so he will
If any.
further, he will also obtain instruction as to whether the other than the terms and conditions within bracket capital A, to stop qualification of bidders, Roman N, capital B, to stop technical specifications, comma, as mentioned in the NIT stroke bid document dated 13/1/2023. The other eligibility stroke qualification criteria mentioned in the tender notice. NIT
26/5/22.
have been retained or not? Have been retained or not? That's all. As agreed to by the learned counsel for the party, lease the case on
510.
So Lordship will indicate that it will remain parted. Otherwise, if it comes up again, go like.
No, it will come, make a mention. Difficulty is there. Make a mention.
Supplementary.
Try to take up a 2 if required. If necessary, we'll fix the case at 2.
Yes, yes, my lord.
Item number 13 and 14.
May please, Lord. In this case, my lord, there is another revision, my lord, filed by one Chitra Das, my lord, wherein the same settlement order is under challenge, my lord. So let this matter be taken up along with these 2 items, my lord. Case number 2. The application number.
Mr. Raichuri, and senior counsel assisted by Mr. S. Vishwakarma. You are a petition.
We are a petitioner, my lord.
Is present. Mr. NC Das, and senior counsel assisted by Mr. Are present. Both side will give. And who is the fishery minister? M. Setial and Junior Government Advocate Assam for the state respondents is also present. Mr. Das, senior counsel referring for the respondent number private respondent has submitted that another repetition.
The WPC number. 2744 of 2022, my lord.
Comma, arising out of the same settlement order. Comma is pending. And the said repetition may also be listed together with these 2. As the learned counsel for the other parties have agreed to the said submission, list the cases, list these 2 petitions Any date?
Right.
It will be tense, but
10. Okay, we'll try at 10.
When-
10. Along with WBC number, part will give you
Publish to lodge.
10.
For hearing, I don't.
Who is the petitioner there?
Well, that one said, well, actually, honestly,
Withdraw that.
no,
Individual.
and we make the council,
Deepika.
Deepika Borgohain.
Permissible?
this is
That's a
this is
really
out of
good.
the same settlement.
Publish to lodge.
Item number 6.
Here, under the Payment of Wages Act, and order before the Labor Relations Come Authority was passed expiring, my lord. We have not received a notice. We filed an application, my lord, under order 9/30. And that was rejected on the ground that there is no provision, my lord, that your losses may come to pay page 29, my lord. He has put up for hearing on the prayer of the petition filed by the office. So they are advocate under
Yes.
order 9/13 CPC section 1,
Page 20.
my lord, page 29, my lord. Interesting. She have put up today for hearing on the prayer of the petitioner filed by the OP, so they are learned advocate on 22/5/13 and the order 9/13 CPC review section 151, as there is no provision under PW Act for this court to reopen the case after passing of an order reward. Hence, the petition is rejected, so order remain. So this is the case, my lord, because so far this tribunals are concerned, authorities are concerned, my lord. Supreme Court has already held, my lord, that the power is there, my lord. It is a review in 80 Supreme Court, my lord, that is being followed by our High Court also. And the
Yes, Mr. State.
paragraph 41.
Which part section?
Paragraph 14, my lord. Other are there also. It may be
Payment of wages. But this is payment of wages actually.
payment also. But there are exceptions, my lord, because
Every act is different, Mr.
this is followed in motor accident claim tribunal also, my lord, by our High Court.
What is the primary order?
Yes, I am coming. Primary order, my lord, that is at page 24. My lord, here, if you are also see page 25,
Let me read it.
yes.
Oh, you are not challenging this.
My lord,
You are not challenging page 24.
my lord, because we have filed an application for setting aside expertise. That is why, my lord, we are coming here. Otherwise challenging, my lord, that is prepared under. Here, my lord, 10 times of the, my lord, the alleged use has been put as my lord. Fine. Two times.
Okay, this 40,520.
Yes, plus 2 times, my lord. Fine.
2 times. Total 1,21,560.
That's all.
Then this is your petition.
Yeah.
Order 9, Rule 11, 13.
My lord.
As per report. Receipt and notice. It was, the main order was under rule, section 15.
Yes, my lord. Second.
After payment order.
There is a set of rules, state government.
My lord.
There is a set of rules, state
Yes.
government.
Ah.
Framed under Payment of Wages Act.
My lord.
Do you have a copy? I think you need not have to draw inferences. Draw inferences from the Supreme Court judgments. It appears to my, if I am correct, it is laid down in the rules for vacation of expertise,
My lord.
right? So you do not have to rely on Supreme Court judgment which has been rendered in Industrial Disputes Act.
My lord.
We are dealing with Payment of Rules Act. Just get that, we'll keep it as part of next Tuesday, or otherwise I'll come across.
Right.
Because see, section 26,
Yes,
here will be the state government is the appropriate government.
yes,
26(1), the appropriate government may make rules to regulate the procedure to be followed by the authorities and courts referred to in section 15.
correct.
And state government has laid down rules.
Yes.
And there is, if I remember correctly, if my memory is right, then there is provision for vacating expiry order. Right?
I'm sorry, my lord.
In this-
I have not.
In this act, my lord, there is also payment of waste procedure rules, my lord.
Ah.
Rules, my lord, 12 provide for appeal.
Let us see. No, that appeal is also there.
Yes, ma'am.
Appeal is different.
Where is the procedure rules?
Payment of waste procedure rules 1937, my lord. Rule 12, my lord.
That is one,
Yes,
but there is another state government rules
yes.
wherein
1958.
provision for vacating
Vacating
expiry
expiry
order
order.
is there.
Yes, madam. 1950. Will do.
Appropriate government is After that, he has the option of appeal. Appeal, right? Instead of writ petition. So there is a already provision laid down. You do not have to refer to this. We have to interpret that. But when provision is there,
My lord,
he says there is nothing.
in the central rule, my lord, I've been, my lord, state rule, I shall see. My lord.
Because it is state rule.
I'm sorry. my lord.
And it is, if that is there, then his page 29 order clearly goes. He says there is no provision. If there is provision, this order is bad.
My lord,
As simple as that.
Yes.
And I think to if my memory is correct, there is provision
maybe, my
for
lord.
expert.
Maybe I have not.
You could have shown it in 2014 itself.
Yes.
I'm sorry.
Expressly wrong. Mr. Chetty, you go through the state government rules
Yes,
also. I think it is there. I could have done the research, but I am not in the, I am having some
Anyway, Tuesday, my lord.
Tuesday. 2 তারিখে কলেজ 2 তারিখে 3 তে Okay, hired Mr. G. N. Shahralal and its senior counsel, assisted by Mr. H.K. Sharma. Why you have not done the homework? You have simply come after 9 years, taking your senior along. And Mr. M. Setia, learned junior government advocate, Assam. For the respondent number 1, 2, 3.
1 and 2. my lord.
And whether this 4 and 5 have been served. Or what?
Yes, yes. They have started, they have filed the agreement.
P. Shane,
Yes, our name has been shown.
the Lord Counsel for the respondent number 4 and 5, comma, whose name is reflected in the clause, this comma is found absent to the on call. Leaves the case again on 810 for further hearing. Just get that rule.
My-
Order is one line.
Yes.
Impugn order is one line, that
Yes,
should be one line.
Yes.
Item number 7.
Yes, Mr. Counsel.
Lordship, in this matter, it has come up after very long and we are having trouble locating the file. So if your Lordship may agree.
Trouble locating the file.
Yes, the Lordship.
Big one,
Lordship,
big one
Lordship.
with LCR.
So any short date as per your Lordship convenient.
40. You are management.
Yes, sir.
What about private respondent? He has entered appearance.
Yes, sir, Lordship. They have appearance in 2018 when the matter had come up. It's all time to file.
Restatement of so and so order,
Reply.
discussing applying for a workman and true implement. Maintainability of the management petition is challenged by the workman across page per country file 18 of the. Okay. On the prayer of Mr.
D. Khan.
D. Khan, Mr. D. Khan, learned counsel appearing for the petitioner has submitted that the brief of the case. Despite efforts, comma, could not be located till date and has therefore, comma, prayed for listing of the case after a week. So stop. Mr. Gugoi, you appear. Clever,
Lordship,
Mr. Gugwe, Gugwe, additional things on the application, because one for one. Is in attendance. But the learned counsel for the respond number 4, whose name is reflected. Cause this, comma is found and sent to them. List the case of the payment by Mr. Khan is accepted, is the for the region cited. Is the case after. 2014 method, to adjourn also that we have to record region.
Item number 8.
What is the subject matter, Mr. Mishra?
Lordship, my sincere apology. This matter is of 2014 and it has come up for the first time. So we need to reconstruct the file. Lordship,
Reconstruct the file, need not have to reconstruct the file, hardly 23 pages, Mr. will give you. Hardly 23 pages,
Lordship,
because you have not filed any affidavit till date, so we are not going to give you any time for affidavit. Am I clear? So get the writ petition along with the annexures from Mr. Mishra.
Lordship.
That will complete reconstruction of your brief, Lordship, because there is no other pleading, right?
Yes.
Mr. R.S. Mishra, learned counsel for the petitioner, and Mr.
W. Ahmed on behalf of B. Chaudhary.
Mr.
W. Ahmed on behalf.
W. Ahmed,
Yes, on behalf of B. Chaudhary.
B. Chaudhary. Mr. B. Chaudhary, representing Mr. B. Chaudhary, that is standing counsel. APDCL. For the respond number 1 and 2. Are present. But previous owners liability,
Yes, but this petitioner,
previous occupiers,
previous occupier, this property is purchased in auction purchase manner. But
auction purchase.
auction purchase. Whether
Mr.
the,
Mishra, you are perhaps in a slippery ground then. Auction purchase. You had auction purchase there.
yes,
What about the service of notice upon the
3 and 4, my lord, service is complete, but nobody has appeared.
which
my lord.
note? Office note is there
My lord, order dated 21/5/2014, my lord.
as per
Law-
order
law
dated
court order.
21/5/2014 of the Loajima Court. Service of notice upon the respond number 3 and the respond number 4 are completed. Mr. Hussain has submitted that he has not been able to locate the brief. Mr. Mishra, learned counsel for the petitioner, shall furnish a copy of the petition along with the annexes to Mr. Hussain by tomorrow.
Ahmed.
Ahmed. By tomorrow. Please the case on next today. All are 2014, we'll try. Find out.
But the judgments I have find out, my lord, but the recent, only one Supreme Court has pronounced one judgment, my lord. That is in a reference case, my lord, that has.
That is gone.
Yeah.
Your ground, your support is removed.
Yes.
Constitution bans.
Yes.